Yes.
But I would like to mention one procedural matter. May I mention, my lord, for
Yes.
witness day?
All right.
Thank you.
This is connected to the further series, which is Doshik is fixed tomorrow.
Hmm.
Motion matter, I have filed today, my lord. I have got the serial number also. Motion may take up this matter tomorrow, my lord.
Motion. You have filed it?
Yes.
All right. You're for the petitioner? Why do you want adjournment? Who, Mr. Borua? On the request made by the request made on behalf of Mr. K. Borua, learned counsel for the petitioner. Matter stands adjourned for the day. Yes.
Made, please, your lordship. So should I beg to mention for listing on contempt matter? May I say on Friday?
You approach the registry for listing. Yes.
I beg to mention item number 41. Item number 41.
Yeah.
Like it
Yes.
wrongly been listed as in the orders column. Let me listen by
Actually, for us.
Whenever you don't make this matter, so they can't list the bigger place again. Due to some person difficulty in these other things. Can be of 25 high.
Who's appearing?
Senior counsel is a bigger.
Leader.
Bigger.
Leader. It is submitted at the bar that the matter has been wrongly listed for orders, and that it should have been listed in the admission column. So stop. Mr. B. Datta, and senior counsel for the petitioner is also said to have some personal difficulty to appear before the court today. So accordingly, matter stands adjourned as paid for. List again. 26.
25 high. You'll be here if that comes to principal.
No, we are going by our diary, okay? 26.
Intend to continue.
Interim order passed today shall continue till then.
Meet visual also. What's I beg to mention item number 33 also. So kindly pass over matter for today also.
You are for the
Petitioner.
as paid for by the learned counsel for the petitioner, matter stands passed over the day.
Also kindly fix a date also. After.
They will fix a date, registry to fix a date.
I'm appearing for second
Yes.
education. Always also.
He does appears for secondary education department. Yes. Huh? Listing of CRP. For what? First time. Pending case, you approach the registry. All right. Yes.
In item 28, we want to file an additional affidavit. Lord.
28.
Yes, Lord.
You're for the petitioner.
Yes, Lord. Oh, it's time.
What sort of additional affidavit?
Lordship, a query had been put as regards the other candidates who have been appointed under the same advertisement, Lordship. So we have got some information. We will file that affidavit.
You are Mr. Day.
Yes, Lord.
Mr. S. Day, learned counsel for the petitioner, submits that he may be allowed to file an additional affidavit to bring on record certain materials which would be relevant for consideration of the extended petition. There's a note. List again after 2 weeks on a date to be fixed by registry. Additional affidavit be filed in the meantime. Why?
See this matter on last occasion, Lordship, spare single consequence.
Ah.
Not the matter.
Ah.
Recorded.
Ah.
In order recorded there, that issue involved in the present petitions are also under from the generation of the Honorable Apex Court. And the outcome of the same could have a bearing on this matter. They therefore submit that since the outcome of this
They submit at the bar that the outcome of the similar case before the Apex Court is still awaited on a prayer made by the learned counsel for the petitioners. Matter stands adjourned. So will list it again? When? After 2 weeks? After 3 weeks? On a date to be fixed by registry.
I'm appearing for secondary
He
education.
does. Okay. Yes.
You mentioned item number 27, and this is in concern with the opposite party, with the person with the question of the problem. will not be able to appear for this other.
Oh, petitioner. Counsel for petitioner. Mr. A.R. Barwa, learned conducting counsel for the petitioner, is said to have some personal difficulty to appear before the court today. On a mention made on his behalf, matter stands adjourned. To be listed again after 3 weeks on a date to be fixed by registry. Not possible. Give a date. If 6. List again on 18/6. Yes.
Waiting is second one for motion.
Please, Lordship. In this case, Lordship, on 27
Hmm.
April, meeting was held and extension has been granted to the petitioner. Extension, he was asking for extension for PhD course. That has been, resolution been passed. However, we have not received the signed my notes yet. Lordship, if my arrangement exists, it may fix on 8th of this month. We'll put it-
Yes.
Resolution passed.
Yes, Lord.
When? Which date?
On 27.
Mr. S.C. Kayal, learned senior counsel appearing for the Assam University, submits that the board had held its meeting on
27 4th.
27/4/2026 and has passed the resolution for
Granting extension.
granting extension to the petitioner to complete his PhD course. Stop. He, however, submits that he does not have the meeting minutes, meeting resolution today, and prays for another date to produce the same. In view of above, list again on 8th of May.
Much.
Lordship is the matter of 8, my lord.
Yes, Friday.
My lord, good things, my lord, comes, good things.
Hmm.
Probably late.
Mr. M. Nath, learned senior counsel, appears for the petition.
Much.
Yes.
Item 2,
Please, your lord.
Hmm.
Here the petitioner is a PhD research scholar. He had some, made his findings sufficient and evaluation we would have also been seen.
Hmm.
Thereafter, it is incumbent on the Gauhati University to conduct a FIBA. But on the alleged ground of some allegation of sexual harassment, Lordship, it has not been conducted. But interestingly, Lordship, the Chancellor, the Honorable Governor, he has directed that FIBA should be conducted. And that order is also part of the record.
Where is that?
And
Page?
I need a page 66. 66. That's the quite as to appropriation. I read it here, page 66. With reference of the I am directed to convey with honorable government central government opinion that condition of conduction of resolution of the candidate can on be held on the basis of some disciplinary proceeding. These are two different issues and be well different names. Procedures for conduction by the HR PhD scholar, department of formal is to be started as per rules. And PhD ordinary you are requested to take necessary action in this regard and submit a compliance report to the office to the undersigned. Thereafter, what they have done, Lordship, last
Hmm.
page 16, Lordship, will kindly see. I submitted a representation. And they have, the registrar has communicated to me through this email,
Hmm.
that an FIR has been lodged. The FIR has no connection with my PhD, Lordship. When the chancellor himself has directed to hold FIBA proceed for final completion of his PhD. And on the last occasion, Lordship, when the matter was listed for the court of first time, it was directed to the respondent to seek instruction.
Yes, what is the instruction?
Please, my lord, I'm appearing on behalf of Mr. P.J. Fupon. My lord, the instruction is awaited in this matter. Instruction is awaited.
Awaited. How long should we, how long should we await?
Granted 2 more weeks, my lord.
2 more weeks. Can't be. We have given time in the month of March. Now we're in the month of May now. I'll give you 1 week time as a last chance. Hmm.
He has been regularly communicating with the university. They have been telling him that since the matter is sub judice, even if he has issued, he cannot do it. So one small observation also.
Yes.
Tendency may not be a part. Tendency. may not
My lord, page 68. May I take your lordship?
be-
Page 68.
I know. Tendency of the part.
Viva voice is only for the petitioner. Okay.
Person who had data submitted the data filing submission, for them, biography had already been.
All right.
Departed.
Please write none holding of viva voice for the petitioner. For his PhD thesis. For completion of the entire process of evaluating his PhD thesis. For award of PhD degree. Despite instructions issued by the Governor's Secretariat through the Additional Secretary to the Governor of Assam, dated 15/12/2025. Bracket annexure 10 has prompted the petitioner to file the instant writ petition. So when the matter was listed on 18/3/2026, 10 days time was granted to the Learned Standing Council, Gauhati University, working instructions in the matter. The matter is listed today. After more than a month, and yet a prayer has been advanced on behalf of the Learned Standing Council, Gauhati University, to seeking some more time. To stop, the Learned Council for the petition has drawn the attention of this court to the communication given to the petitioner by email by the registrar of the university, stating that the Executive Council, through its resolution dated 11/11/2025, has resolved to file an FIR against the petitioner for a case of grouping, GROPING. What is grouping?
Risking. Risking.
Risking.
Get hold of.
Okay, grouping.
He denied.
Pursuant to the observation made by the Internal Complaints Committee.
My lord, para 3 of space 68 is relevant in this.
The Learned Council submits that the filing of FIR would not to hold a viva voce of the PhD thesis of the petitioner to enable him to get his PhD degree. And therefore, the respondent university should be directed to hold the viva voce. What is there in para 3? What is there in paragraph 3?
Para 3, my lord, the reason why his PhD has been kept on hold, my lord, there has been 2 complaints before the Internal Complaint Committee of sexual harassment against the petitioner, my lord. The findings are shocking.
There is
No, but-
final order, but there is no penalty order as such.
My lord,
They are
he has,
competent to-
they have filed an appeal, and this appeal is pending before the disposal before the higher educational institution, means the registrar, my lord.
Appeal.
Appeal,
Where is it?
appeal, my lord, in his pleading.
Page 47. Against the recommendation of the ICC, I submitted the appeal from reply dot, proposed reply, page 47. Thereafter, it is incumbent on them to impose a penalty if they deem fit lordship. But no such penalty order has been issued. My appeal is dated 20 to 10/25.
Appeal against what?
The recommendation of the ICC was
My lord, ICC recommendation on page,
44 lordship. ICC recommendation, page 44. And thereafter,
Now show me the relevant portion.
page.
Recommendation.
Para 1, 2, 3, 4, 6 recommendations were there, but from the ICC. my lord.
Hmm.
one of the recommendations.
These are the recommendations. Now, recommendations are recommendations, either good or bad. Has it been acted upon?
Yes, my,
No final.
it has to be placed before the Executive Council of the Gauhati University.
So, Lordship,
It has not been placed.
It has been,
page 21, Lordship.
No, we are on the delay part, merits or demerits, whatever it may be. What's taking you all so long?
Page 21. Against this recommendation, they have sought for my so-called reply. Come, page 21. On 17/10/25. Page 21. Page 21. Immediately within 5 days, I submitted my reply. Page 21. There it goes. With reference to the above and consequent upon submission of recommendation of the report of the ICC, chief relating to the written complaints filed recently, this is to inform you that the said report of ICC that also has been provisionally accepted. You are hereby directed to show cause as regards the aforementioned recommendations of the ICC within 10 days as per rule 86. Thereafter, I submitted my reply. Page 48, 47.
Where is the beginning of the report?
Gotcha.
Beginning of the report.
Next page, 22. 21 is the forwarding letter.
Hmm.
Starts at 22. Ends at 36.
And what is the date?
it is
Date of the report. Page 22, Lordship, see all the endorsements are dated 1/9/25.
Not all, one is second line also. External member has signed on second line.
September, Lordship, it was communicated to me in October 17/10/25 by page 21 letter.
Next para. It is seen that pursuant to the recommendation of the Internal Complaints Committee dated 1/9/2025, the petitioner has been issued a show cause notice, white communication dated 17/10/2025. To submit his reply within 10 days. And the petitioner has submitted his show cause notice, his show cause reply on 22/10/2025. But it appears that no penalty or final decision has been taken. Except for informing him that it has been decided to file an FIR against him.
Section 13 code sectionalization text 13 says, the recommendation is to be actively Section 13.
Although 2 weeks' time is prayed for on behalf of the Learned Standing Council, Gauhati University, but court is inclined to grant only 10 days time as a last chance. List again on so and so. We'll see.
May not be a part.
One more line, pendency of this writ petition shall not be a bar for the respondent authorities to
On the next step.
hold the what do you call, the viva voce.
On the next step, kindly on the next step,
On the next date, what?
observation will be made.
No, we'll have it now only. Next case.
The petitioner here is the right principle of the Mahamudra. Earlier, the present incumbent holding the post of principal in charge. It was decided through an earlier round, filed by me, that he is not eligible to hold the post of principal, as he doesn't have the eligible qualification of doctorate degree. Therefore, she could not have been promoted as in-charge principal. But you could see the earlier round of litigation.
Page?
Page 16, it starts. Page 20. Page 20 is the paragraph 9. The service conditions of a faculty member of Government Section Mahavidyalaya Gauhati is governed by NCT Commission of Norms and Procedure Regulation 2014. Thereof provides for the qualification for the post of principal of an institute governed by the state regulation 5.2. So and so, lots of qualification is stated for principal HOD. It's postgraduate 55%, PhD in education or any number 3. That is the essential qualification. At last, logic. Further, as per notification dated 24/6/2019, the Gauhati University authorities had also provided that NCT guidelines is strictly followed by the principal director of teacher training colleges affiliated to Gauhati University, wherein clause also 5.2 of the regulation was incorporated. In other words, we have to understand that prescribed qualification for the post of principal Government Section Mahavidyalaya Nagaon would be provided as per 5.2A of the regulation of 2014, while providing for eligibility. Providing for the eligibility educational qualification, which stated that the NCT regulation also provides that any deviations thereof may lead to withdrawal of recognition of the institute. Now, finally, at para 12, in view of the aforesaid proposition of law, in the instant case, we have arrived at conclusion that even for the purpose of being in charge principal Government Section Mahavidyalaya, the incumbent who is allowed to be in charge principal must definitely have the required educational qualification and eligibility as prescribed under the regulations of 2014 of being a principal of the institute. There are 16 from such point of view, the conclusion that can be arrived at is that the additional deputy commissioner who is made the in-charge principal of Section Mahavidyalaya as per communication legislation does not have the necessary qualification and eligibility for principal, because nobody at that time, including respondent number 9, nobody had the qualification, therefore the ADC was with the in charge. Having set aside the appointment of the ADC, we now require the competent authority to appoint any other suitable person who has the necessary qualification for the purpose of in charge principal.
You will issue notice.
Well, petitioner has already retired.
But we are seeking a power input.
They are seeking what?
Power input.
Heard Mr. B.P. Bora, learned counsel for the petitioner, who submits that the respondent number 9, despite not being qualified, has been appointed the in charge principal of Nagaon Shikshan Mahavidyalaya, presently known as the College of Teacher Education, Nagaon. So the learned counsel submits that earlier, the respondent authorities had given the charge of the principal of the post of principal to the additional deputy commissioner, bracket education, Nagaon. Of the petitioner being aggrieved had challenged the same by filing WPC number 3001 of 2022. Stop the writ petition was disposed of by judgment in order dated 19/5/2023, wherein the court held that the person to be posted as in charge principal is required to fulfill the educational qualification criteria. And the criteria, and we can say that even on the in charge basis. And therefore, the appointment made in favor of the additional deputy commissioner was interfered with, and the respondents directed to fill up the post in accordance with law. So despite the same, the respondents have once again appointed person who is not qualified to hold the charge of the principal. We above issue notice of motion returnable by 4 weeks. Posted. So learned studying council. Higher education, is it? What is this? Higher education,
Elementary, madam.
elementary.
Elementary there, madam. And Department of School Education. I
Department of-
respondent 1 to 6. madam.
You are appearing as what? Standing council
Standing also.
of
Elementary Education Department. I can represent, madam. Respondent number 1 to 6, madam. And 8.
accepts notice on behalf of respondent numbers 1 to 6 and 8.
When you put the government.
Who's the government? Government advocate? No, and nobody today.
I is registered.
Okay, please, sir. Please, sir, guess number two. Please, sir.
P. Saikya, government advocate.
Yes.
Mr. P. Saikya, and government advocate, accept notice on behalf of respondent number 7. Petitioner to take steps for service of notice upon the respondent number 9 by speed post within 3 days. List again after 4 weeks. Appointment of the respondent number 9 shall be subject to the outcome of the litigation.
Less.
Simple.
Mm.
Oh, Lordship, kindly bear the last order, Lordship. The instruction was called for.
Who's respondent number 6?
I have been asked, right, personal number 6, second wife of the deceased employee, who died in violence in year 30. So thereafter also several litigations will move before this honorable Lordship, and this is now finally Lordship decided the matter.
Page? Where is it?
Lordship.
Final decision.
And then if Lordship start from base 43 Lordship. The common judgment passed in WC 659 of 2022 and WC 561 common judgment Lordship.
Who filed the writ petition?
Section part is at page 54.
Who had filed the writ petitions?
That file, filed by the respondent number 6.
6. And you also filed. Both of you.
Both the petition, yes, number 6,
Both case.
both case.
Sophia Begum.
Yes.
Sophia Begum and Sophia Begum is same.
Same. I'll Halima. So, Lordship, page 54 is the directly portion. Page 54 actually. Upon perusal of the judgment Lordship. Okay, fine. After this order, Lordship, this judgment, Lordship, the authority has taken final decision, Lordship, that is start from page 56. Final decision of the authority.
Just a minute. Junufa Bibi's case also has been referred to, isn't it? Junufa Bibi, then pursuant to the judgment, the rule of 143 was amended.
Yes, Lordship. Amended.
Pension rules.
143.
Then it says that
Quoted in the amendment, quoted in the order judgment itself, Lordship, page 54 onwards now. Page 50 onwards.
family pension shall be paid to the eldest eligible member of the family, who shall divide it equally amongst other individuals.
Lordship, I am the eldest surviving widow, Lordship, and that's why, Lordship, the authority decided that I am entitled to pension for family pension, and I am liable to maintain the respondent number 6.
Order was passed,
Lordship, order was passed.
56.
Is 56, starts from page.
In the relevant portion.
The portion is page 59.
Okay, this was in the year 2024.
24 Lordship.
Then what happened?
Thereafter, nothing happened, Lordship. No, since then, Lordship, I'm not getting pension, Lordship, because, Lordship, there was an interim order in that matter, Lordship. And in the interim order, Lordship, the PPO issued in favor of Liva State, Lordship.
And in the final decision, lordship, this output has stated that the decision has been taken by the respondent authority, the interim order shall be continued. Since lordship on 30/12/2024, the final decision has been taken, lordship, now interim order is not operating. But even then, lordship, I have not been paid the family pension, though I am entitled, they are still there.
Yes, what is the instruction?
My lord, as per this honorable court order, pension has been settled, my lord. In wife, my lord.
That we have
So,
seen.
my lord, that department requested the director, my lord, of the concerned department, to secretary.
What is required now to be done? Director. Director of? Hmm. What they are supposed to do? No, they will separate means, in what will be the ratio?
And if they are, it's not an option to get, even the settlement, but if they are putting an action on the settlement, that's the
What was your husband doing, working as during his lifetime? Hmm. Assistant teacher, Hindi.
Serving as the assistant teacher in Hindi subject.
Hmm. Okay, what is your name? What is your name? Your name? Your name? Your name? Your name? Heard Mr. J. Abbas, learned counsel for the petitioner. Mr. P. Saikia, learned government advocate for the state, and Miss S. Sutia, learned standing counsel, elementary education department. Stop having regard to the nature of grievance projected by the petitioner, comma, the read petitions taken up for disposal at this stage. Next para. The petitioner and the respondent number 6 are the first and second wife of late Sudula Nia, who died in harness on 23/2/2013 while serving as assistant teacher, bracket Hindi, at Joy Bhoom ME School under the jurisdiction of District Elementary Education Officer, Golpara. Stop. The respondent number 6 initiated 2 writ petitions, that is WPC number 6259 of 2022 and WPC number 5613 of 2023, claiming family pension and other pensionary benefits. Now, both the writ petitions were taken up together and disposed of by the common order dated 16/12/2023. I'm sorry, 6/12/2023. By relying upon, no full stop, okay, continue. By relying upon the notification dated 9/8/2018, by which Rule 143 of the Assam Services bracket Pension Rules, 1969 was amended. In view of the full court decision rendered in Musammad Junufa Bibi versus Musammad Fatima Begum, alias Fatima Bibi, and 4 others, reported in 2023, 5 GLR 824. Stop. Rule 143 of the pension rules, in short, provided that the family pension shall be paid to the eldest eligible member of the family, who shall divide the same equally among other eligible members. Stop. The respondent authorities were accordingly to take a decision in the matter, and as directed, the Secretary to the Government of Assam, Department of School Education. White order dated 30/12/2024. Decided that the instant petitioner, being the eldest surviving widow, would be entitled to family pension. But the family pension received by her would be received as a trustee, okay, TRUSTEE, trustee, for all such persons who are eligible to the family pension, including the respondent number 6. Stop. In other words, the petitioner would be liable to maintain the respondent number 6. Failing which, the respondent number 6 would be entitled to seek relief in accordance with law. Stop. The Learned Council submits that despite the order dated 30/12/2024, the respondent authorities have failed to grant any family pension to the petitioner till date. And therefore, she is before this court through the instant writ petition. Stop. Next para, when the matter was listed on 18/3/2026, Mr. P. Saikel, Honored State Counsel, was asked to obtain instructions in the matter. Stop. Today, he submits that the Director of Pensions has written to the Department of Elementary Education, as well as to the Treasury Officer of Golpara, to take necessary steps in accordance with the court's direction dated 6/12/2023. So that the Director of Pension can take necessary action. PPO has to be issued from your side, isn't it, Mr. Saikel? No, you have called back the both halves. Page. This has been issued to you. There was an interim order earlier. So the both halves of PPO was called back. Now it has been returned back. Okay. Next para, it is therefore notice from the above developments that the issue has already been decided by this court as well as the Department of School Education through the order dated 30/12/2024. So, as such, what is the step to be taken now? Hmm. As such, the respondent, as such, the director of elementary education, bracket respondent number 2, shall call both the petitioner as well as the respondent number 6 for execution of a bond by the parties concerned as to how much of the family pension would be shared between them, so that the benefit of family pension can be given to the parties without further delay. Respondent number 2 shall therefore take necessary steps in accordance with law within a period of director. 2 months. Isn't not too long a time? What did I say last time? In accordance with law of 2 months from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of. Yes. Hmm. Hmm. The 1 year mandatory means 1 year of what? Uh, uh. No, 1 year for what? Uh, regular 1 year service required. Uh, uh.
Remains under the block time. Then we start this earlier, countless to very pension. Then in case of which is state color. And you see.
1 year of service after regularization. That is the requirement. Hmm. You don't have your husband did not have that service. Oh. Okay, so So how does it help you? How does this judgment help you? This was claimed for CPF. Yes, Mr. Saikia. Seems to be a covered case.
Then I buried them and it three should
No, it has already been decided by this court. Whether there any appeal has been filed. Manjula Ray Adhikari, this judgment. Notice only. Why not we dispose it of and consider in terms of this judgment? I'll tell you the facts of this case. Manjula. As per the impugned communication dated 4/11/2020, don't write. The petition of the petitioner, the prayer of the petitioner for payment of compensate family pension has been rejected by the respondent number 4 on the ground that the husband of the petitioner had not completed minimum period of 1 year of complete service so as to permit sanctioning of compassionate family pension. So it's the same thing here. Here also only 10 months, 7 days. 10 months, 7 days. We'll dispose it off. No point keeping it pending. Start, Mr. A.Y. Chaudhary, learned counsel for the petitioner, Mr. Saikia, S. Saikia, na? A. Saikia, P. Saikia, learned state counsel, and Ms. M. Das, appearing on behalf of Mr. S.K. Modi, who represents respondent number 3. Having regard to the nature of case projected by the petitioner, the writ petition is taken up for disposal at this stage. Next para, it is the case of the petitioner that her husband was initially appointed as SSA teacher in the year 2017. And he rendered continuous service for about 7 years as a contract teacher. Stop. Thereafter, he was regularized and appointed as a regular assistant teacher on 2/9/2024. Stop. After serving for 10 months and 7 days as a regular teacher, he expired on 9/7/2025, leaving behind the petitioner and their 2 minor children, and also his aged mother as dependents. Stop. According to the petitioner, they have no other source of income except from the salaries received by her late husband. Stop. The petitioner therefore approached the respondent authorities concerned for grant of family compassionate family pension. Where is there's no notification. You're not annexed. Any communication given to you about that 1 year? Then you, on your own, you have filed this representation. Page 24. Then you file this representation. What made you file the representation? What is the last line? Please read. By submitting our representation on 24/11/2025. Respondent concern, I said. Approach the respondent concern. After respondent concern, you write bracket respondent number 4. Stop. However, since the petitioner was verbally informed that as her husband did not complete 1 year of service after regularization, compassionate family pension cannot be granted to him. The petitioner is before this court. Learned counsel for the petitioner submits that the case of the petitioner is squarely covered by the decision rendered by a coordinate bench of this court in WPC number 4491 of 2021. Bracket Manjula Ray Adhikari versus State of Assam and 8 others. Close bracket, wherein this court provide judgment and order dated 10/6/2025 came to a finding that in order to come within the definition of open inverted comma, government servant, close inverted comma, then comma, it would not be necessary for an employee to be in a permanent service under the government. And that even temporary employee under the government of Assam would come on within the definition of government servant. Government servant, again inverted comma. To stop such an interpretation was based on the definition given under rule 2 bracket small e of the Assam services, open bracket, discipline and appeal, close bracket, rules, comma 1964. The learned counsel, after full stop, in order to in support of his submission, has produced copy of the judgment in order dated 10/6/2025, rendered by a coronate bench of this court in Manjula Ray Adhikari Supra. Stop, upon careful perusal of the said decision, it only appears that the case of the instant writ petitioner is squarely covered as well. Stop. No material has been brought to the notice of this court that the said judgment has been interfered with by a higher forum. Accordingly, the writ petition is disposed of by directing the respondents to provide the compassionate family pension to the petitioner in accordance with law. In terms of the decision referred to herein above. without delay. The petitioner shall submit a copy of the, who's the authority? The writ petition along with the judgment an order rendered in Manjula Re Adhikari Supra before the Director of Elementary Education, bracket respondent number 2. And upon receipt of the same, the respondent number 2 shall do the needful. For grant of compassionate family pension scheme to the petitioner. And the process of granting the such benefit should be completed. Should be done and completed within a period of 3 months from the date of receipt of a certified copy of this order. N Fukan, SC elementary for 1, 2 and 1, 2 and 6. Yes. All right.
Item 6.
Keep this in that file. Not inside the file. Keep it with you in that thing. What is the matter otherwise? Suspension.
Possibly initiated against the petitioner stands disposed of possible lordship. But your lordship, last paragraph, second last paragraph, your lordship. Therefore, in view of the available court direction, the period of suspension is regularized only for the purpose of pensionary benefits.
Okay.
And the amounts which was received by the petitioner, retired assistant teacher of a Gauhati high school during the period of suspension will be his entitlement, and he shall not be entitled to any other financial or service benefits for the said suspension period.
Okay. Mr. Counsel, you quickly recite the facts. What was he? Assistant teacher. Suspended, then? Then? Suspension was on the because of some FIR or some arrest. Convicted. He filed revision. Then?
Then I was thinking back and his suspension order, I had superintendent of PDP. During the period of suspension.
During suspension, you had superannuated. Then?
Then I submitted a
For? No, you had superannuated during suspension. Where is the question of reinstatement?
If mine was the value close, then there's reinstated me.
Where is that page? Before that, you show me that acquittal.
The judgment is a 355. But when I filed a review petition, that conviction was taken. The sentence was taken, that is the misforgiven. And all throughout they never indicated the part of proceeding against me.
Okay, well, after this judgment, what happened?
Prior to that, I had placed before find out the family came from the day 52. 9/11/2023. They had regularized my loss. Restated my loss. The period of suspension will regularize the outcome of the above section, case number 4. Considering the above facts, in view of the legislative benefit of one of my other jurisdiction, it was restated with effect of 28/2022. Then we can find the declaration my loss, which is pending before the government share.
You are reinstated after what? After the judgment of in the revision court?
Before one.
Before? On what basis?
We have filed a declaration that restriction is pending. Because our pension or provisional pension was not paid. The declaration, I have annexed a copy of the order, that is a page 64.
.497. WBC 497.
After that, 21.
No. 4971. What was the basis of your instatement?
The basis of they have not paid any pension to be made. Then after that, my lord, on 21/2026, and order was passed, case 67. Whereas I was excluded. Then the next day, at least 70, order was passed. As to whether the services of the petitioner has been recruitment in what, the order on 29/126.
Where is that?
Case 70.
These are the orders passed in the same writ petition. Now, there's only one writ petition. What have you challenged the writ petition? Your suspension. What is your relief you are seeking in writ petition? Not in this one, in this WPC number 4971. Pension. And in this writ petition?
Whereas if OHO is under the jurisdiction of OHO was placed under suspension by the then inspector was told by the OHO. Whereas the established interest of service of 22. And whereas that was received from the Director of Secondary Education, needed OHO for disposal of the matter in compliance with the order passed to WPC to the positive with the due to excess pensionary benefit. OHO, he was reinstated in service with effect from 28/2022 for the purpose of presenting his pensionary benefit. Now, in consequence of the honorable Gauhati High Court judgment on the order being given, where the judgment and order in the was set aside and was the defendant was executed on charges under 492/90C. Therefore, in the judgment of the honorable court, the failure of suspension is regularized only for the particular pensionary benefit. The evidence has specified dependent on bonafide right to the period of suspension and will be his entitlement and which shall not be entitled to any other financial or benefit for state suspension period. Consequently, the disciplinary proceeding there was never a disciplinary proceeding initiated against me, my lord. If after this, I was suspended, my lord, no more any notice was issued to me for asking me to appear before the disciplinary proceeding. I have made a categorical statement in my petition, my lord. And paragraph 20. And page 52 or also the fact is
What are you receiving as on today? Provisional.
I think
You're getting provisional.
now the expectation. In file of the IDC case 52. They have themselves admitted that there is no department proceeding against me. This will also not council appearing to submit that specified instances will receive. The petitioner was put on suspension by disciplinary operating and then was considered to after suspension that the petitioner was neither illustrated nor directly this department proceeding in court against him. So the penalty which they are trying to impose now, without, there was never any disciplinary proceeding.
What has happened to your writ petition, the earlier one? Pending. Please write. I heard Mr. S. Count, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 3/13/2026, bracket annexes 17, by which the period for which he was kept under suspension would be restricted with the benefit already granted to him. Stop. The learned counsel submits that petitioner was placed under suspension for the period between 10/12/2004 to 28/2/2022. And he superannuated from service with effect from 28/2/2022. While under suspension. Stop. In the meantime, the criminal case by which, what is the penalty? Yeah, penalty in the bigamy case by which the petitioner was convicted for charges on bigamy was interfered with by the revision court by acquitting him from the charge. But despite the same, since pensionary benefit was not given to him, the petitioner filed WPC number 4971 of 2022, which is still pending as on today. Stop. In the meantime, the impugned order dated 13/2/2026 has been issued, depriving the petitioner of the service benefit during the suspension period. Despite the fact that no department proceeding was drawn against him. Stop. Aggrieve the petitioners before this court. Issue notice of motion returnable by 4 weeks. Ms. P. Das, standing counsel. Secondary accepts notice on behalf of respondent members. Which respondents? 1, 2, 4, and 6. Mr. P. Saikya. Appears, Lana State Council appears for respondent number 5. AG, Give one name. Mr. R. Talukdar, Learned Standing Counsel AG Assam accepts notice on behalf of respondent number 3. Notice is complete. Petitioner to serve requisite copies of the petition to the learned counsels appearing for the respondents today within 2 days. When is the other matter going to be listed? No date. List again on so and so. On 10/6, along with WPC number 4971 of 2022. Yes. Hmm. 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 Yes. Hmm. Hmm. Where is that? Recovery. Page. Hmm. How much is to be recovered? This is the amount to be recovered from you. Hmm. Excess drawal started from which date? 1/5/2001. And you retired on? Hmm. Yes, what do you say? Hmm. Oh, can it be disposed? Hmm. Sorry, will be covered. No? Please write down Headmaster. P.K. Das, learned counsel for the petitioner. Mr. P. Saikia, learned government advocate. For respondent number 4 or 5, Ms. P. Das for SC secondary. SC secondary for 1, 2, and 5. 1, 2, and 3. Ms. R.M. Barua, SC finance for respondent number 6. So, having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Next paragraph. The petitioner retired from service on 30/6/2021. As what? He retired as what? As assistant teacher from Rangia Higher Secondary School under the Kamrup District Circle. But despite retiring, he has not been paid his pension. Till date. Stop. According to the petitioner, the Directorate of Pension had raised an objection, alleging that the petitioner alleging that the pay of the petitioner as on 1/5/2001 should have been fixed as rupees 4120, but instead he was given rupees 4480. Stop. Therefore, there has been an excess drawal of pay with effect from 1/5/2001 till the date of his retirement. That the petitioner has no role. Respondents cannot seek such withdrawal. Cannot seek recovery of the same. Stop. He submits that the principal of the school has calculated the excess payment given to the petitioner to be an amount of rupees 240,660.70. And the same has been communicated to the Inspector of Schools, Kamrup District Circle, Amingaon, on 9/2/2026. Stop. It is therefore for this reason that the petitioner has been deprived of his pension till date. Stop. The learned counsel submits that the case of the petitioner is otherwise covered by the decision of the apex court rendered in State of Punjab versus Rafiq Masih, reported in 2015, 4 SCC 334. More particularly at paragraph number 18 of the said judgment. So the learned counsel submits that copy of the submits that paragraph 18 of the said judgment has been abstracted in the writ petition against paragraph 9. Next para, upon perusal of the contents of the writ petition, as well as the decision of the apex court in Rafiq Masih Supra, it only appears that the case of the petitioner is squarely covered by the said decision. Accordingly, the writ petition is disposed of by directing the respondent authorities to process the case of pension of the petitioner without further delay. And at any rate, within the outer limit of 2 months from the date of receipt of a certified copy of this order. Yes, that'll do? No.
Followed the petitioner before your lordship is a followed headmaster of NME school, my lord. Implement order, my lord, at page 98. Here in this case, my lord, though, my lord, as per the order, implement order, petitioner was found, my lord, he is not guilty of withdrawing, my lord, any amount for his personal, my lord, misappropriation. Nevertheless, my lord, his suspension period was regularized and one increment was, my lord, withdrawn. I beg to, my lord, show the background of this case here, my lord.
This is a second round.
My lord.
This is a second round.
Second round, earlier one was for reinstatement, my lord. Therefore, this honorable court directed to reinstate him, my lord, forthwith. Accordingly, he was reinstated and thereafter this order was passed. Here in this case, my lord, once, my lord, recently building grant of ₹20 lakhs came to the school. Then, my lord, earlier ex-president started to, my lord, disturb the petitioner to take some, my lord, money, my lord, for his personal use, my lord. But this petitioner, my lord, vehemently objected thereto. And accordingly, my lord, one report was also, my lord, page 20, annexure 2, was submitted by the concerned authority, CRCC, my lord. And in this report also, my lord, page 21, my lord, relevant portion, here it was also, my lord, mentioned that this ex
See, Mr. Counsel, at this stage, what can be done? Will issue notice?
Yeah. Yes, sir. Notice may be issued, my lord, this impugn order, my lord, so far, my lord.
So I'll be filing my consolidated affidavit, my lord. At this stage, my lord, notice will be issued.
Lordship, can you look here?
As a connected matter, my lord, item 19 also, my
No, my
lord.
lord,
This one.
This is connected, maybe some.
There's
sort of
another matter, my
connection
lord,
is there.
is fixed today.
But here, my lord, in the order, my lord, itself, my lord, and there are, my lord, lot of, my lord, favorable reports came to the authority, my lord. Nevertheless.
We'll examine that. At this stage, notice will go, that's all. Hard, mister. And what we are learning counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the order dated 26/3/2026, by which although his suspension period has been regularized for the purpose of has been regularized as on duty. No, has been regularized and treated as on duty for all purpose, but one increment with cumulative effect has been imposed as a penalty. In view of above, issue notice of motion to turn over by 4 weeks. Mr. Alex, Summon Council. The Demonstrate Education accepts notice on behalf of the respondent. On behalf of respondent numbers 1,
1, 3, 4, and 5.
1, 3, 4, and 5. And Ms. R. M. Barua, SC Finance for respondent number 2. Notice is complete. Petitioner has some requisite copies.
18 is the connected matter, my lord.
Same, my lord. Notice me go. Item 18 is the same petitioner, my lord. Connected matter. That was
Extra
same, my lord.
copies. In 2
It is
days.
19.
19.
19.
19 only thing is that, my lord, here, my lord, it is period is regularized, but that seller is not paid.
Then, my lord, notice me go, my lord. I'll get my instructions. Same.
19.
Item 19, right, pardon, Mr. Yan Bob, let me counsel for the petitioner who submits that filing this petition, the petitioner place for a direction to the responding authorities concerned. We grant him the area salary amounting to rupees 125,765 for the period from 7/10/2024 to 28/2/2025. By adjusting the subsistence allowance already granted to him. Issue notice of motion terminal by 4 weeks. If we can. SCS, Elementary Education Exception Notice on behalf of respondent numbers 1, 3, 4, 5. 1, 3, 4, and 6.
And 6, my lord.
And RM Barua for respond numbers 2 and 5. Copies complete, extra copies 2 days. List again. Along with WPC number 2253 of 2026.
Next.
Deep look.
Item 9.
May I please, your lordship?
Yes.
Lordship, here the petitioner initially got appointed on 8/9/2017 as a contextual teacher under the elementary department. And subsequently, my lord, his service was regularized by order dated 21/9/2024, and his joining was posted at Fakirpara LP School under Soigao DO. But the fact remains that, my lord, that headmaster of that particular school is not, my lord, allow him to joining that particular school.
Why?
There are so many allegations that he demanded bribe, as well as he is biased from the communal angle also. And to this grievance, he had petitioner had visited DO, BO, as well as director also, but nothing has been done. So hence this petition. So that, my lord, his reappointment order is at page 39. Kindly find. His posting is, my lord, Fakirpara LP School. And another fact in this case that, my lord, after passing this order of appointment, the petitioner has not been provided any appointment order of joining letter also, and also release order. And on the practical ground, it is headmaster is opposing. So I have submitted representations, several representations. Lastly, I have submitted representations. It is at page 40 before the Director of Elementary Education, seeking that alternative place of joining may be provided to join this petitioner.
Why you're not being allowed to join?
My lord, basically, the headmaster of that Fakirpara LP school, initially when I was got appointed as a contractual teacher, I was transferred to the school, and I was running my duty. But in the meantime, some occasions were there that, my lord, I gone, my lord, on leave, and show cause notices were issued against me. But that leave was that on medical ground. But that particular headmaster of that school did not process my leave application with my lord biased approach, that he from the beginning started to oppose this petitioner to joining this school on the ground of communal intention, that the petitioner belongs to a opposite faith of the headmaster. So he was, my lord, fully against for joining this school by this petitioner. And also it is a demand that he demanded bribe from this petitioner, that if you want to join this school, you have to pay this and this.
Where is the order? Where is the order by which you have been asked, you have been posted?
My lord,
Your appointment order?
appointment order is last, it is 39, page 39.
What is 36?
My lord, 36 is that it is show cause notice. I was served.
Any particular order you agree with?
Order that is inaction, that I have
Which one? Which is
submitted
the order? Point out
representation
the order.
before the, my lord.
Which is the order by which you have been posted to that school?
Yes, it is page 39. Page 39, my lord.
39.
Yes.
Which school is that?
It is, my lord,
Fakirpara.
Fakirpara LP school.
You're not allowed to join here.
Yes, my lord. Under Soigao, BO, my lord.
By the principal.
Yes, my lord.
Then what did you do?
I had, my lord, given representations before the Director of Elementary Education
Page?
at page 40.
This is for application seeking for alternative place of posting.
My lord, yes, alternative posting. And I had.
What is page 42?
Yes. Page 42, my lord.
What is this? Same thing.
This is the order. My reappointment, my lord.
Reappointment.
Yes. I was initially contractually appointed.
See,
Thereafter,
page 39 and page
yes.
42 is one and the same thing.
Same thing.
Same
my lord.
thing.
It is a type copy.
No, this is not a type copy, it's the original copy. Photocopy.
Oh, annexure.
Heard Mr. So-and-so, learned
Yes,
counsel
sir.
for the petitioner who submits that Despite issuance of order dated 21/9/2024,
Hello.
the petitioner is allowed to join the place of posting at Fakirpara LP school.
Kirpara LP School, my lord.
Issue notice of motion, return by 4 weeks. Mr. G. Pegu, Lanet, Government, Lanet,
Elementary education, my lord.
Standing Council Limited Education, accept notice on behalf of respondent numbers 1, 2, 3, 4, till 4 only, 1 to 4. SSA, Mr. So-and-so, Lanet Council appears for respondent number 5. Petitioner to take steps for service of notice upon respondent number 6 by speed post within 3 days. List again also. Extra copies within 2 days. Next, 4 weeks.
Obligation.
May I blush?
Hmm.
My lord, the petitioner was suspended, thereafter he has been reinstated, my lord. But my lord, I take a notion to page number 19, my lord. So it's 1958, annex 19. While the departmental proceedings was going on, my lord, the petitioner was asked to appear. At that point of time, he has submitted some allegations as to why he led to place in a suspension, my lord.
Now, what
first-
are you aggrieved with?
Grievance is that, my lord, I have made allegations in the departmental proceedings that that some financial irregularities took place in the school, my lord. And I have pointed out, and for that only I have been placed in a suspension by the, this is the main background. Well, I put to, I have,
During the departmental proceeding,
yes, I have placed it
drawn against you.
against me. I've been placed in a suspension on the ground that I was absent for half an hour in the school. This is the ground of suspension. Whatever, my lord.
No, before suspension, there was already a departmental proceeding going on.
During suspension, after suspension,
What started first? Suspension started first.
suspension studies.
Now, what is this case?
Page 58, your lordship, company.
Page 32, whose case is
58.
this?
And I'm reading, my lord,
Dipayan Paul, this is your case.
yes, paragraph 3 from
This is
the
the
bottom.
second round.
Uh,
Is this a second round?
this is a second round. My lord, paragraph 3, I'm reading from the
No, don't read, don't read.
Bottom.
Tell me what happened in the first round.
first round, my lord. He has been reinstated, my lord. He has been reinstated.
You were aggrieved with the suspension order in the first round.
Yes, they were
Correct.
reinstated.
Then you have been reinstated.
Reinstated. And this is the case with regard to praying for a direction to cause an inquiry into the allegations which he has made in the during departmental proceedings
Against whom?
against the district level authorities, including some private respondents.
Proceeding is drawn against you. Again, in turn, you have again made some allegations against somebody.
Yes, lordship, yes.
Where is that?
That is my lordship will find in page number 58. This is recorded in the paragraph 3 from the bottom.
58.
I'm reading from the bottom. Your lordship will come to paragraph 3. Whereas the inquiry committee scrutinized the matter, verified all relevant documents, as well as perused the written statement of such and such, and found anomaly in the utilization of government fund in the school concerned, as alleged by such and such, for which the matter needs to further verification.
So,
Yes. And I take your lordship thereafter to page number 76.
so as a result, your suspension has been extended
Suspended, extended, thereafter I have been reinstated.
or reinstated. This
Reinstated
is
thereafter.
prior to your reinstatement.
But that portion of inquiry has not been done. Which I have made allegations.
Where is your allegation?
Allegations, my lord, I have given in the written statement. Written statement, page number 55.
Read,
My lord, page 56, your lordship will come. Second paragraph.
read.
That from a reliable source, I have come to know that actual amount of money granted for construction of boundary wall of the school was 9 lakhs. The breakup being first phase granted 3,60,000, second phase 3,60,000, and the third phase 1,80,000. All this amount, all these grants were made for covering the running boundary of 65 meters. All all sides taken together, an iron gate and plant also included. When I asked the CRCC that the amount, actual amount sanctioned for the construction of boundary wall of the school was 9 lakhs and not 7,20,000, she threatened me and their consequences if I disclose these secrets to public. She further instructed me to sign the resolution book without any fuss, but I refused to sign it. That madam on such and such date I attended school on time and registered my attendance in the such and such portal within such and such and put my attendance in the attendance register. You also will find here, he has stated the 65 meters of running wall. For that purpose, 1 meter, my lord, you also will find at page number 76, as per government approved rate is 7,300. 7,300 is the per meter cost as per government approved sanction, page 76. And they have sanctioned 9 lakhs.
You have been reinstated.
I have been reinstated.
What is the stage of the departmental proceeding?
Departmental proceedings, my lord,
Completed.
completed. They have not come to this, they have not inquired this, they have admitted there is some allegation, misappropriation.
No,
but
leaving that aside,
yes.
what is the stage now? Of the
Inquiry has not been done completely, my lord. They have punished me with 1 increment deduction. Why?
Where is that?
And that is I put to challenge, my lord. In another writ petition is pending.
Huh? Which writ petition?
WBC 1288, my lord, page number 68.
What did you challenge there?
That is my reinstatement punishment only. Not reinstatement, punishment of deduction of 1 increment. That is put to challenge. Not is issued, my lord.
Did you issue notice then?
Yes, yes.
Mr. B. Prokashka,
My lord, one thing I like to point out, my lord, there is a specific allegation against him. He come to the school at 9 AM and after punching the time, my lord, he has left out for a school, my lord. That allegation is page number 15, my lord. Then, my lord, one so-called issued to him for hearing that allegation. He has raised certain allegation against other person in his WS, my lord. He come before this honorable court that action has to be taken as part of his statement of the WS, my lord. And my understanding, my lord, this repetition is not maintainable. His allegation is, my lord, clear. He is called for this hearing on the allegation, my lord. Why he is absent, my lord, after giving the attendance, my lord. Then he, my lord, raise allegation in this WS, my lord. It's not a specific allegation in before the authority, my lord. WS, my lord, he have to reply it, my lord, not the raise the allegation at the other person. My lord. Come to the page number 15, my lord. Page number 15, my lord, statement of allegation, my lord. There are 2 points, my lord. That why you were working in so-and-so school, Hailakandi, you were found absent in this school after giving attendance in Shiksha Setu portal when Assistant Deputy Commissioner visited the school on 14/8/2024. Number 2, that you always come to the school at 9 AM, but after giving the attendance in the Shiksha Setu portal, you immediately leave the school for other purpose. That is his allegation, my lord. On that basis of allegation, my lord, that notice issued in page number, my lord, 54, my lord. For hearing, my lord, of 16/5/2025, my lord, he called. Against that, my lord, he submitted, my lord, written statement, my lord. In the written statement, he raised the allegation against other person.
Where is the WS?
That is, my lord, page number, my lord, 18.
18.
Reply not 18, sorry, annex 18, page number 55. My lord. That is reply against that so-called notice. He has raised allegation here, my lord.
Anyway, we'll issue notice. What else can be done at this stage?
My lord,
Maintainability will be kept open.
Otherwise, my lord, this is not maintainable because my lord, that reply statement, my lord, he have to reply the specific queries in regards to the allegation. My lord.
Understood already.
My lord.
You file your affidavit.
Original case, my lord, he is
You will,
submitting that
you will
matter.
file your affidavit to raise the question of maintainability. We'll consider that at the appropriate stage. Not Mr. B. Prokashta, Learned Counsel for
And
the
moreover, my
petitioner.
lord, he have to submit before the authority properly, my lord, he have any grievances against that person, my lord.
Who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to inquire into the specific allegation made by him in the so-called reply submitted by him on 16/5/2025 before the Director of Elementary Education, which also was reflected in the order dated 24/10/2025, by which the period of his suspension was extended. So the Learned Counsel submits that without making any inquiry into the allegation made by him, the respondent authorities have imposed a penalty of withholding one annual increment with cumulative effect, right order dated 21/2026. Stop next para. The Learned Counsel submits that the said order is put to challenge by the petitioner in another writ petition, that is WPC number 1288 of 2026, which is pending consideration. The Learned Counsel also submits that the petitioner had earlier approached this court against his suspension by filing WPC number, which is the first one?
My lord, page 32. 4482/2024.
Page number?
32, my lord.
WPC number 4482 of 2024. Which was disposed of by order dated 6/9/2024.
Yes.
By directing the authorities concerned to consider the appeal filed by the petitioner as regards his suspension. Next para, at this stage, Mr. P. Saike, another government submits that the writ petition is not maintainable in view of the fact that the petitioner has not submitted any separate allegation or complaint, but is seeking inquiry of the matter in view of the statements made by him in his reply to the show cause notice. First off, he submits that petitioner is required to submit his reply to the show cause notice and not make further allegation against other persons. And therefore, the instant writ petition is not maintainable. Next para, in view of above, we should notice a motion returnable by 4 weeks. Mr. P. Sekar and its standing government advocate accepts notice on behalf of respondent numbers
I'm for 3 and 4 now.
3 and 4.
Five, six,
Mr. G. Pegu accepts notice on behalf of respondent numbers 1, 2, 5, and 6. Petitioner to take steps for service of notice upon the remaining respondents by speed post within 3 days. Extra copies be furnished to the learned councils appearing today within 2 days. Maintainability of the writ petition is kept open to be considered at the appropriate time. List again. Should we club together or not?
Yes, sir.
List again with WPC number.
1688.
Sorry. Which case is pending?
1288 2026.
1288 of 2026.
Obliged.
My lord, in this case, my lord, the petitioner has challenged the order dated 10/4/2026.
10-4.
What has happened, my lord? This is a second round of litigation, my lord. Earlier, my lord, I had filed an application for correction of my date of birth long back in 1986, my lord. 1986, there's a receipt at page 27. And I had also filed an application, but a copy of the application is not with me. This page 27 indicates that if my lord may kindly peruse page 28, this is the copy which I have. D//birth correction, date of birth correction, 1612, page 28, my lord. So this was the application which I submitted in the year 1986. Page 28. Thereafter, my
receipt.
86. This is the receipt, money receipt, my lord, of rupees 40. D. Bormont, that is the petitioner, my lord. Then, my lord, at page 29 is the other application, 12/11/87, correction of date of birth. I have stated that instead of 1967, it should be 1970, my lord. As per the school admission register book.
No, go back to page 28. Where's the date?
This is the money receipt, my lord.
I know, but
1612, down below, my lord.
when was it submitted? Which year?
86.
How do we know? It's not written there.
223/86.
What is this?
1612.
What is this? Roll number or something?
This is roll number.
Roll number is of 86, but when did you submit this?
1612/86, my lord.
That 86 part is not there.
They are not disputing that, my lord. If my lord may kindly peruse.
They're not disputing it. I think that's what they're saying, that
Page 43.
43.
They're not denying that there is no money receipt. They are saying there is a money receipt of 86 and then there's an application of 87. This is the impugn order which I have challenged.
Correct. So it says that
and moreover, my lord, I had filed applications under the RTI seeking for these two documents. They have not been able to furnish to me as of date.
application is of the year 1987. Money
Yes.
receipt in 1986.
Yes,
This is what they're saying.
they're saying. But even then, my lord, there's a notification of 1990 at page 48, which says, my lord, that after the examination is held, within 3 years, I have to make an application. So if that be the case, my lord, my examination was held in the year 1986 and I have submitted my application, even if I don't consider 1986, I have submitted my application in the year 1987. That is within just after a year, my lord.
The earlier writ petition was disposed of.
Dispose of.
What was
My
the
lord,
direction?
dispose of the, my lord.
What was the direction?
Direction is a page 38, my lord, starts from 38. Operative part is at page 40.
Okay, no reason was assigned for entertaining, that's why. Will you issue notice?
Yes, my lord, notice. my lord.
Heart, Mr. S. Count Learned Counsel for the petition.
This case, Lordship, Accountant General has met party also. In earlier, your Lordship also reflected that AG has no role to play. Lordship, in this case, Lordship, he is seeking changing of date of birth, Lordship. So, Office of the Accountant General has no role to play, Lordship.
As of,
So
let them
minor-
remain, my lord. Let them remain, my lord.
They are unnecessary dragging, Lordship. Why AG is met party, Lordship? That is, we have no role to play, Lordship, in respect of correction of date of birth, Lordship.
But it might have some effect later on, my lord.
So he's thinking
Prior
about
is
the,
only for Lordship.
Mr.
correction,
Count is thinking about the future.
Lordship.
Mr. Count is very hopeful. In future, writ petition will be
Lordship,
allowed.
Then if any situation.
Then
arises,
Accountant General
if
will-
any cause of action, then it is to role to play, Lordship. But here in this case, Lordship, as per.
In a way, he's right. They have no role at this
Yes,
stage.
Lordship,
At
as
this
per
stage-
prior Lordship, prior is Lordship to make necessary correction of age, Lordship. How is come, Lordship?
We delete the
Yes, Lord.
Accountant General or
Yes.
At this, my lord, let them remain, my lord. Let them file an affidavit.
Lordship, in last order also, your it was reflected, Lordship. In the last order, your Lordship has passed, Lordship. That paragraph, page 40, Lordship, paragraph 5.
what did I say?
No, only the submission was recorded.
Let me pass the order now. I've heard enough. To submit that this is the second time the petition is before this court. Stop. He submits that the issues with regard to the change of date of birth of the petitioner as paid for by him since the same was wrongly recorded. As 15/5/1967, whereas it should have been 15/2/1970. Stop. The writ petition, the first writ petition, that is WPC number 5368 of 2024 was disposed of by directing the respondent authorities concerned to hear the petitioner and file and to pass a reasoned order. So accordingly, the Secretary, Assam State School Education Board passed an order on 10/4/2026 rejecting the prayer of the petitioner for change of date of birth. Sub agreed the petition is again before this court. Next, para Mr. S. Count Learned Counsel submits that the petitioner had indeed submitted his application for change of date of his birth within time. And therefore, the reasoning given in the impugn order dated 10/4/2026 cannot be sustained. Full stop. He submits that even if the date of the application is considered, he submits that even if, okay, the date of application is to be considered as 12/11/1987, the same is within time, since the notification of SEBA SEBA provides that correction of date of birth can be done within 3 years from the date of commencement of the examination. In view of above, issue notice on motion returnable by 4 weeks. Mr. Talibda, Lanet. You are appearing for?
Lordship, I'm for respondent for my lord.
Lanet Council. Oh, 4. 4 will not issue notice at this stage.
Yes.
I'm appearing for respondent number 2.
Before that, I think Mr. Bhuya is there. Mr. S. Bhuya,
1 and 3.
Lanet Study Council. Higher Education accepts notice on behalf of respondent 1 and 3. Mr. D.K. Roy, Lanet Study Council. ASSEB accepts notice on behalf of respondent number 2. Petitioner to take steps for service of notice upon the respondent number 5 by speed post within 3 days. To stop at this stage, notice is not issued to respondent number 4. Next para. Extra copies be furnished to the Lanet Council's appearance for the respondents today within 2 days. List again, also answer. You were it. You should. How many more? Okay.
May I please, Your Lordship?
Yes.
Lordship, here the issue is that basically whether the Udaya score, which has been asked for the 18 months DLED course employee candidates, that is mandatory or not. That is the basic issue, basically. So in that regard, the Honorable Division Bench also recently has passed the judgment. So though it was not the whether it is mandatory or not, it was not considered, but my lord, may kindly come to page 79, my lord.
Yes.
Second paragraph, the first paragraph, my lord, thus with such undertaking by the applicant applicants, we consider that this appeal and the interlocutory applications ought to be closed, sustaining the judgment impugned in this appeal in its entirety, with the only caveat that the applications of the applicants shall be verified by the state on the basis of the documents furnished by them, and if some of the documents demanded by way of notification dated 17/6/2025 are not furnished, the same will be verified from the state records database, and in the event of the rejection of their applications, each of the applicants shall be communicated further. So basically regarding 17/6/2025, that notification I have also challenged here. But my lord, my challenge is basically whether it is mandatory or not. And in this case, already another writ petition has already been filed and notice were issued, and that is fixed on 13th of May, my lord. That is writ petition 842 of 2026. So my humble submission before your lordship that notice may be issued and may be tagged with that writ petition, my lord.
What is that page number?
Writ petition 842 of 2026.
842. 842.
842 of 2026, my lord.
Okay. Yes.
They'll by this honorable court, my lord, may peruse page 93, my lord.
93.
93, my lord, from bottom, my lord, second paragraph, the applicant and applicant have challenged, my lord. Lordship got it,
93 of
93 of the petition.
কোনটো petition? নে ভুল বেলেগ petition আছে?
93 is something else in my copy.
Hundred আছে না?
Subject আছে। Lord, my lord, here issue is that on 19/11/2025, that is my impugn order, your lordship, at page 72.
Yes, what is this?
Page 72 is my impugn order, my lord. So it is for information of all the candidates who have successfully submitted their online application against the Directorate of Elementary Education, Assam. Advertisement A and B, file number so and so dated 8/1/2025 for recruitment of regular teachers of LP and UP schools that they need to submit the details of HSLC examination and NIS UDIAS. So basically, these persons are having 18 months DLED course, my lord. And the history of this 18 months DLED course is started from the year 2017, my lord. In the month of August 2017, the RT Act was amended, whereby it was mandated that within 31st March 2019, the person who are in service and having no qualification under the NCT guideline, my lord, NCT minimum qualification. So they need to acquire that qualification within 31st March of 2019. And therefore, this 18 months course was formulated by the MHRD through NIS, my lord. So that originally the DLED course is of 2 years, and that has been 6 months reduced to 18 months. And therefore, this issue has went up to Honorable Supreme Court. Honorable Supreme Court has decided that on 10th of 2017, the person who are in service, they will be eligible for recruitment, my lord. And thereafter, this notice was issued on 76/2025 in another advertisement, my lord. And in this advertisement on 19/11/2025, they are requiring that UDIS code for ascertaining my stand as a in service as on 10/8/2017. So my case is here basically is that, so on 10/8/2017, all the schools were not having the UDIS code, my lord. That's why it is not mandatory. It cannot be mandatory for all the persons, my lord. That is basic challenge here, my lord.
That's why within bracket it is written for whom it is applicable.
Yes, that is applicable for us for the 18 months DLED course, my lord.
Well, this is.
For these petitioners, my lord. So now they are asking anything. So they cannot ask anything, my lord, to ascertain our in service. We are ready to provide our joining letter, experience letter, everything, my lord. But regarding the UDIS code, so my submission is that that was not mandatory on 2017 for all schools. And in this regard, I have annexed some documents also, my lord, notification at page 97, my lord.
'97 is the impugn order.
Yes, 97 is the order, my lord. If your lordship will look at that, it was issued by the Secretary Government of Assam, Department of School Education. So it was of order dated 76/2025. Lordship, if I may read, my lord, second paragraph, whereas, well, I'm reading from the top, my lord. whereas it is mandatory for all government, provincialized other schools under the government and private schools of all levels, starting from lower primary, upper primary, high school, up to higher secondary school, in the state of Assam, shall mandatorily have the UDAS code under all circumstances without any exception. That is right, my lord. Thereafter, my lord, whereas it has come to the notice of the Department of School Education that some schools are yet to obtain or assign with the UDAS code. So it is clear from 2025 order itself that it was not acquired by all the schools, my lord, as on 10/8/2017. Sorry, in 2025 itself. So my basic submission is that on 10/8/2017, it cannot be used as a mandatory requirement to ascertain my in-service position, my lord. So that's why that similar matter has been already pending on 13th of May, my lord. That may be along with that may be tagged with, my lord, after issuing notice.
It is not similar because my lord, this notification was challenged in my lord WPC number 3974, my lord. This honorable court, my lord, after going all these things, my lord, that was dismissed, my lord. Against that, my lord, they had preferred, my lord, read April 345 or preferred 25, my lord. Not the petitioner, my lord, either similar person, my lord.
Which was?
Rupam Roy, my lord, 340 WA 345.
Yes, already I have submitted that read appeal order, my lord.
My lord, that judgment, my lord, may peruse internal page number 76, my lord.
Page?
Internal page judgment of the internal page, my lord, page 76.
At page 93.
70. Internal page judgment 76.
76, you say?
76, my lord. the
Yes.
Last from bottom last, my lord, the appellant applicant, my lord. My lord, got it, my lord.
Yes.
Have challenged the judgment and have sought to have the notification dated 17/6/2025. This is the challenge in this petition also, my lord. Quas and a direction to be issued to the state to allow them to participate in the examination selection process without submitting any additional documents, and also to keep as many numbers of the post vacant as are the numbers of the applicants and applicant in the interrogatory applications listed with this appeal matter.
My lord,
Yes, sir.
may I clarify, my lord, what she is reading, my lord? I have not annexed that. So I don't know from where.
He has not annexed, my lord. I have produced it before this honorable court.
I have already produced it
My lord, me period next
at the
is
beginning itself.
77, my lord.
My lord, though it was discussed, but it was not considered.
My lord, me page 77 last by referring to the facts and the above, my lord. It was discussed and it was referred, my lord. Internal page 77 last para, my lord.
Even if it is considered this writ appeal order, my lord, then also I am covered with that. But my contention is that whether it is mandatory or not, that is my basic submission. But it was not decided on that issue, my lord. That whether it is mandatory as on 10/8/2017 to ascertain the in-service position.
Page 77, my lord, last para referring to the facts of the case, my lord, the learned single judge appointed the judgment notification was only a necessary verification mechanism to implement the NCTA guideline and the Supreme Court's direction, and it did not in any way create new eligibility condition, ma'am. The instance on the documents according to the learned single judge was very reasonable to prevent any fraud, and in absence of any manifest arbitrariness having been shown by the petitioner's appellant, any interference by this honorable court was unknown. And this my lord, order is only confined to that appellant or appellant matter, because my lord may produce last judgment para of the last judgment.
The merit lists have been published already.
Yes, my lord. Yes.
So now what do we expect?
My lord, if my expectation is that my cutoff mark is more than the already selected candidates. So
But then-
if I can success in this case, definitely,
Then you don't have that and
My lord.
yours, you dice,
yes,
which according to you is not compulsory
yes,
at the relevant time.
yes, that is my case.
Then what does this judgment say, which you
My lord,
produced?
My lord, this judgment basically earlier, it was challenged basically in of the advertisement of 2023 regarding that notification and of 17/6/2025.
Hmm.
And this notification, I have annexed it at page 99, my lord, requiring 6 numbers of documents, my
The
lord.
writ petition was dismissed.
In the
And in the-
single bench, that was dismissed.
Dismissed. Appeal
And,
also it was
I-
upheld.
Yes,
In appeal also it was upheld.
though it was upheld, but that was considered as at page 79, my lord.
Hmm.
There are two way out, my lord. Lordship may dispose it of this matter in tune of this writ appeal order, number one. Number two, Lordship may keep it open regarding the issue of maintainability of not maintainability, mandatory requirement of this UDAS code, my lord. And that issue has already been pending, and in another writ petition, I have already stated, my lord.
So let it come up together then.
Yes, my lord.
842.
Yes, that is my only submission.
So, my lord, in a similar.
Then the issue will be settled, my lord. Otherwise, that will be lingered again.
Well, then, both the case may heard independently, my lord, because facts are different, my lord.
My lord, same advertisement challenging by the same identical candidates, my lord. How?
Was challenged, my lord, that was dismissed against the order, my lord. Division bench of this honorable court has also passed the order, my lord.
Do you know what is there in, what is challenged in 842?
My lord,
My lord,
842.
DRO, my lord, DRO.
Just a minute, I'm asking
Yes,
now.
yes.
Do you know what is challenged in 842 of 2026?
That is my 7/6/2026.
Huh?
That same, my lord, 17/6.
So if it is the same, why do you object to listing this matter with that case? Let it be listed on that day. If it is required to be heard separately, we'll
Yes.
hear separately.
Part may get open.
Heard Mr.
BM recommender.
DM Deka, learned counsel for the petitioner. It submits that by filing this petition, the petitioners have challenged the notices
Yes.
dated
1911.
19/11,
My lord, if I go
2025.
in sequence, then 17/6/2025.
Just a minute.
Yes, my lord.
Notices dated 19/11/2025, 27/11/2025, order dated 17/6/2025, and the notice dated 10/3/2026, which are annexes 7, 8, 14, and 23 respectively. On the ground that at the time of admission to the 18 months DLED course in NIOS, UDAS code of the school was not mandatory. To show that they were in service. So, however, by the impugned notices and order, the same has been made mandatory, and thereby depriving the petitioners of being considered. For appointment to the post of lower primary teachers and upper primary lower primary teachers and upper primary teachers. Despite having scored good marks. Stop the learned council submits that a similar issue. A similar writ petition is filed wherein the issues involved are similar. Stop the writ petition being WPC number 842 of 2026. The learned council submits that the same may be taken up. No, submits that the present case may be taken up along with the said writ petition. Next, at this stage, Ms. S. Chutia, learned Standing Council, Elementary Education, submits that the issue has already been examined by the coordinate bench of this court. Case number has not been mentioned anywhere.
My lord,
WPC number 3794.
Okay. In WPC number 3794 of 2025.
Party's name Rupam Roy versus Stable.
Bracket Rupam Roy and 97 others versus State of Assam and others.
170.
Okay. Rupam Roy and
170.
170 others. Instead of 97. Versus State of Assam and others. And this court, right,
Order dated 24/9/2025.
order dated 24/9/2025. Dismiss the petition. Stop agree. The petitioners filed writ appeal number 345 of 2025. On the division bench, right, order dated 24/3/2026. Did not interfere with the finding of the learned civil judge. Stop. She therefore submits that the very maintainability of this writ petition is in question. Next paragraph. Considering the fact that a similar matter is said to be pending, this court finds it appropriate at this stage to issue notice of motion, making it returnable by 13/5/2026. Ms. S. Sutia, Learned Standing Council,
1 and 2 I am paying.
Elementary Education, takes notice on behalf of respondent numbers 1 and 2. While
three also it is. Petitions, I said.
C also, Director, 1 to L3, huh? While petitioner to take steps, anyone, any Standing Council, NCT,
Yes, they are, but they will appear after issuing the notice, my lord.
okay.
NCT and NIOS also.
They have a Standing Council.
Yes, yes.
Petitioner to serve notice to the respondent numbers 3 and 5.
4 and 5.
4 and 5.
4 and 5. Standing Council
Yes.
through their Standing Council within 2 days, and thereafter file the acknowledgement receipt before the registry to show proof of service. Extra copies of the writ petition be furnished to Ms. SCPL, Learned Standing Council, Elementary Education Department within 2 days. There's this matter along with WPC number 842 of 2026.
Much obliged.
May I please, Lordship?
Hmm.
Regarding this case, Lordship, the petitioners were appointed as a temporary grade 4 employee in the year 1994. And they accordingly they were paid salary up to the month of May 1996. And thereafter their payment stopped. Why not we file a repetition for this honorable court that was disposed with an observation that the petitioner has made out a case and direction was issued to Lordship to make the payment and to regularize their services. That was not complied with, Lordship. Although the petitioner did not file any contempt case, subsequently they filed a writ petition. And that during the pendency of that writ petition, Lordship, they passed the impugn order rejecting the claim of the petitioners, saying that they are not entitled because they were work against non-retention post and their appointments were not as per the law laid down, Lordship. So
Which is the first writ petition?
the first
Is it
writ petition, Lordship, is
56.
56 and relevant, Lordship, 61. And before that, your Lordship, kindly page 60, para 6 also.
Hmm.
There are 6. 6, 8, and 9.
You are appointed against sanction post?
My lord. That is very much reflecting the appointment order. Appointment was made by the Director of Secondary Education, sir. I have annexed those appointment orders and the extension orders.
What are you seeking here?
My lord.
What are you seeking?
Seeking, Lordship,
Regularization.
regularization as well as the area salary, Lordship.
Hmm.
And one of his colleague, Lordship, has approached before this honorable court. And that writ petition was disposed of, that is page 80. And in that case, only direction was sought for payment. No regularization was sought for. And this honorable court directed them to release the payment with interest. That is page 80. And
Page
relevant
18, 18.
no, 80. One of his colleagues, they were, Lordship, altogether.
It was not a case for regularization, only a
No,
case for payment
only for payment. That
of
case,
area.
that case was only for payment. And this
There were
one,
7 of them.
Lordship,
There were 7 writ petitioners.
here, Lordship, 7. In that case, Lordship, 1. Only 1. They were altogether, Lordship, 12 employees under similar categories.
In that case means that page 80,
Page 80.
there are 7 petitioners.
Sorry, Lordship. Page 86.
What is page 80?
80 is the order, Lordship. After passing the impugn order, this writ petition was closed.
Your
Our
writ petition.
Our writ petition was closed. And page 86 is the order passed by this.
How many writ petitions have you filed so far?
2 writ petition are there, 2 writ.
This is the third one.
No, third one, not this is third one. This was filed by another minor colleague of the present petitioner, Lordship. Their names, Lordship, altogether 12 names were there. And out of this 12, one is Lordship Anukumar Jadhav. He is not within the
Mr.
same. He is not within
Mr.
the
Khan, why to make things difficult?
Lordship.
This is your third writ petition, I think.
Lordship, page 86 in relating to
56 is one of your writ petition, 80 is another one, and this
Yeah.
is the third one.
Lordship, this 7, page 86 is not belonging to these 7 petitioners.
Nobody is talking about 86. I'm talking about 80.
86.
80.
80.
80.
80, Lordship, this is all these 7 petitioners.
That's what.
Yes.
Before that, 56 is also your writ petition.
Yes, all these 7 petitioners.
Page 80 is the next one,
Yes, next one,
and this present case is the third one.
third one.
So that is what I'm saying. This is your third writ petition.
Earlier, Lordship, I told Lordship, earlier 2 petitioners.
You don't understand what I'm
Yes,
saying,
Lordship.
just saying yes, no, left and right like that.
I'm sorry for that, Lordship, because I thought that the earlier 2 rounds of petition. And so for this present is concerned, Lordship, this is happening.
Question is your first writ petition 5075.
Lordship.
Since there was no instructions, court disposed of,
Yes,
saying the government should examine it.
yes, they were
Correct.
directed examine.
That was regarding what? Regularization,
Regularization and payment of salary,
salary also.
Lordship.
Then what happened after that?
They did not comply with the order. And
Uh,
the petitioner also filed to file a contempt case. They did not file also contempt case.
so you file a second writ petition.
Second writ petition in the year 2024,
That is this page 80.
page 80.
Now 80 was disposed of in what manner?
That is, Lordship, during the pendency of that case, they passed the impugned order.
Which is?
That is page, Lordship, 76. That is the impugned order. In view of this impugned order, that writ petition was closed.
Your 76,
76.
it should have been the next in sequence. You have to come back again to page 76 after going to page 80. What was the finding?
Finding, Lordship, page 79.
Please read.
The Honorable Supreme Lordship, start from Lordship, page 78, paragraph. Further, it is after table, Lordship.
Yes,
It
read.
is stated that all the petitioners are working in non-retention post of grade 4 in different secondary school. They did not receive salary from June 1996 onwards due to non-receipt of retention from the government, and most of the posts were filled up through ADR 1 and ADR 2. Though the petitioners are claiming that they are regularly working in the school, but during the hearing process, they were miserably failed to put authenticated documentary evidence in support of their claim. Further, it is observed that the appointment of the petitioner were in violation of statutory recruitment rules and in violation of provision of Article 14 and 16 of the Constitution of India, and therefore petitioner have no right for his post and to claim salary. The Honorable Supreme Court in cases of state of Orissa so and so, reported in so and government of Andhra Pradesh have held that no person can be appointed without advertisement and participating in the selection process, and mere continuance in service wrongly appointed in post do not confirm such appointee any right to claim any relief, including salary and the liability of the state to pay salary to a teacher appointed in the recognized school would arise, provided the provision of statutory rules are complied with. Not after extracting a service for around, Lordship, 3 decades.
Okay, let's continue. Next, then you file the writ petition.
Yes,
This had to be closed.
this is, yes, this is the close, writ petition and
Withdrawn. Close withdrawn. Clause
Right.
has withdrawn.
Yeah.
So thereafter, they have passed this order at page 16. I mean, page 84.
No, 84, Lordship, that is relating to another case. Yes, that was the case of my colleague, of our colleague.
Today, what are you challenging? Annexure 14?
Page 76, yes, Lordship.
Okay.
And we are referring page 84 and 86.
Now 86 is another case by
Another
somebody
case.
else. This was regarding salary only.
This was regarding only salary.
So it is not similar to your case.
Exactly similar, but in that case, Lordship, only payment was sought for. If your Lordship kindly come to page 70 for a moment, your Lordship will find the name of that person.
Okay, but what was the direction in his writ petition?
Yes, in that writ petition, Lordship, page 93, your Lordship may kindly, paragraph 14. By
What is the salary?
Yes, by a mandamus of this court, the respondent number 3, Director of Secretary, is directed to release the area salary of the petitioner with interest 9% per annum from the date of 1/6/1996. From the same date, Lordship, we are claiming till the date of payment. Further, it is provided that the respondent number 1, Secretary to the Government of Assam in the Department of School Education shall conduct an inquiry as to for whose fault the post created by government number so and so would not be retained, and who is responsible for non-payment of salary to the petitioner for the long period. And if in the process any officer is found responsible for the same, then the interest to be paid to the petitioner shall be recovered from the salary of hearing officer.
Will you issue notice today?
Lordship, notice and regarding Lordship, present service only status quo as on today, Lordship, that may be because after passing the impugn order, that is page 76, Lordship, they are, Lordship, apprehending that they may be removed from the service. So they are still working, Lordship, and status quo as on today, that may be directed to be maintained, Lordship.
Where have you stated that?
Yes, Lordship, page para 22. Page 15.
Yes, anybody appearing?
And for the secondary education department.
Yes,
They were initially temporarily appointed. And my lord, moreover, as per that order also, a hearing was conducted. And here also in the remark column, it is clearly stated, cannot consider as he was working against the non-retention post, and there was no advertisement formal interview when he was appointed. So in all other cases also similar remarks were made. So my lord, at this stage, my lord, notice may be issued.
Please not. Part Mr. M. Khan, learned counsel for the petitioner, who submits that petitioners are yes, who submits that by filing this writ petition, the petitioners are seeking regularization of their service and also for release of their current and area salary with effect from 1/6/1996 till date. Stop. He submits that the petitioners initially approached this court by filing WPC number 5075 of 2012, which was disposed of by judgment and order dated 17/7/2018. After coming to a prima facie finding that the petitioners were appointed on ad hoc basis and against sanction post, and they have continued as such for more than 20 years. So, however, the respondent authorities were directed to examine the respective claim of the petitioners and if it was found that they have been continuing as such without any interim order of this court, their case be processed for regularization as per law. Along with the payment of area and current salaries. Stop person there too, since no steps was taken in furtherance of the direction given by this court. The petitioners once again approached this court by filing WPC number 5138 of 2024. Stop, however, during the pendency of the writ petition, the respondent authority concerned white hearing report dated 16/3/2026 came to the conclusion that the petitioners were working in non-retention posts and were unable to produce any authentic documents in support of their claim that they have been working continuously since their appointment. It was held that they do not have any right to the post or claim salary. So as such, the writ petition was withdrawn with liberty to challenge the hearing report dated 16/3/2026. The petitioners therefore have filed the said writ petition for the third time. Mr. M. Khan, Learned Counsel, submits that pursuant to passing of the impute order, the petitioners also apprehend that they may be released from their service. Therefore, we praise that their service be protected pending final consideration of the incentive petition. Next, para review of above, issue notice of motion returnable by 4 weeks. Mr. U. Sharma, Learned Standing Counsel. Secondary education, accepts notice on behalf of respondent numbers 1, 3,
1, 3, and 4.
and 4. Ms. R.M. Barwa, SC Finance, accepts notice on behalf of respondent numbers 2 and 5. Notice is complete. Extra copies. I'm sorry. It's Ali, not that. It's Ali. Extra copies we've served within 2 days. It is further provided here in that. The respondents shall maintain the status quo. It is provided that the status quo be maintained as regards the service condition, service position of the petitioner. As on today.
Status quo is not, status quo may not be applicable, may not be considered here, my lord. As because they are temporarily appointed initially. And moreover, they have no advertisement and no.
So you get the instructions, we'll file an affidavit, we'll dispose of the writ petition. They have been continuing till now, so
Yes.
at least that should be protected. Yes, next case.
May I please do those? In this case, your lordship, the petitioners' services were provincialized, your lordship, as tutor, your lordship. Assistant Professor Tutor, your lordship, will kindly come to page 33 and excerpt 5. First, your lordship will find Mohammad Akbar Ali, Tutor Assistant Professor, Political Science. Date of joining was 17/8/1998. Now, your lordship, the UGC, your lordship, has made it mandatory, your lordship, from the year 1998. The qualification of need, your lordship, for appointment as assistant professor, your lordship.
Hmm.
Just prior to that date, your lordship, was initially appointed, your lordship. Now, even though he should have been in the exempted category, his service was provincialized, your lordship, as tutor. And subsequently, your lordship will kindly come to page 37. A proposal, your lordship, was submitted, your lordship. It was, and director sent it to the government and government replied to it regarding proposal for creation of 2 posts of assistant professor for provincialization of 2 numbers of tutor assistant professors. Now, in inviting reference to the subject and letter cited above, I am directed and informed that as desired by Additional Chief Secretary, Higher Education Department, a meeting was convened on 18/9/2020 to examine the proposal for upgradation of tutor assistant professor, tutor librarian to assistant professor librarian, during which Additional Chief Secretary has directed to re-examine the proposal in the light of up-to-date UGC guideline. You are therefore kindly requested to resubmit the proposal. Then, your lordship, what has happened thereafter, your lordship, is not known to us, your lordship. Although the page 32, your lordship will get that from 32, it can be presumed that those who were appointed prior to 24/12/1998, they were, your lordship, so far as the condition of NET, SLATE, MPhil, and PhD was concerned, they were in the exempted category, your lordship. And based on that, your lordship, proposal was submitted. Next, your lordship, proposal was.
This page 32
32,
is only a submission of some details of some persons
lordship.
working before
Lordship.
24/12.
All details of the persons who were appointed prior to that date, your lordship, were sought for.
What does it suggest?
It suggests that there is an exemption for those professors who were appointed prior to 24/12/1998. That is the date on which UGC regulation came into force, your lordship.
And you were appointed on?
I am appointed on, your lordship will find at page 33, date of joining 17/8/1998. Serial number 1.
17, okay, 17/8/19.
Now, since, your lordship, the first proposal was sought to be directed to be submitted, your lordship, what happened to that proposal, your lordship, we don't have any idea, your lordship. The government is also sitting over the matter, therefore I am before this honorable court.
For
Your
what
lordship,
purpose you have filed this writ petition?
for, your lordship, upgradation, your lordship,
Upgradation
as assistant professor, your lordship, not as a tutor assistant professor.
Your services have been provincialized,
Lords,
correct?
lords,
And proposal was made for creation of 2 posts
2 posts, your lordship,
of
that-
assistant professor.
lordship. I include in this 2, your lordship.
What is the criteria?
That, your lordship, only they can disclose, your lordship. That is why, your lordship, in tune with the regulation, it was directed to be.
No, but how do you say that you qualify for that assistant professor?
That is, your lordship, that is the from here, your lordship.
Hmm.
Because that proposal has been, your lordship, may kindly come to page 37 again, your lordship.
Proposal is not by name. It just says 2 posts.
That is, your lordship, pursuant to our proposal, your lordship, in respect of us.
But how do we know that?
That, your lordship, I have made a statement, your lordship. What was your statement?
Otherwise, you are tutor,
Tutor, assistant professor.
tutor assistant professor.
Those candidates who does not possess the required qualification, your lordship, they were, your lordship, provincialized as tutors, your lordship. In colleges, tutor assistant professor, and in high schools, your lordship, tutor and assistant teacher, your lordship. They got fixed pay, your lordship, not the scale. But subsequently, there is a division bench judgment, your lordship, when rules were challenged, your lordship, directing the government to pay minimum pay scale to these people. That has not been complied with. Your lordship may issue notice at this stage and ask them to file an affidavit, your lordship, on this, your lordship. And in fact, your lordship, Page 36, the letter of the principal, your lordship.
Your prayer says that you should be provincialized,
Lordship, provincialized as
but you have
assistant-
already been provincialized.
Yes, your lordship, as assistant professor, your lordship. That is the,
So even for the post of assistant professor, you have to be provincialized
lordship.
separately. Again,
Your lordship will kindly respond on authorities to provincialize and upgrade the service. That's the prayer.
upgrade is one thing, but provincialize, you've
Lordship.
already been provincialized. as tutor.
Specialize as tutor, then your lordship, in fact, it's your lordship, my main prayer is for upgradation.
As assistant professor. And thereafter what? Professor.
No, your lordship, in colleges, there is no post of professor, only assistant professor
Assistant
and associate professor.
Oh, after assistant will be associate.
Associate. I don't know whether I will get to that position or not.
No,
because-
supposing you are provincialized as assistant professor. Again, you have to be provincialized if you are to be
No,
promoted.
I need not be provincialized, upgraded. Once I got upgraded as assistant professor,
Hmm.
then I will automatically get promotion to the associate professor if I qualify, your lordship. But that, your lordship, probably I will not get since I don't have the doctorate, your lordship, PhD.
Yes, what do you say?
Sir, notice.
Heard, Mr. S. Thakur, Leonard Senior Counsel, assisted by Mr. J. Abbas for the petitioner. Who suppose that by filing this writ petition, the petitioner prays for the direction to the respondent authorities concerned to provincialize and upgrade his service as assistant professor from the post of tutor assistant professor with effect from the date of his provincialization. That is 14/5/2022. Staff the Learned Council submits that a proposal was submitted to the Director of Higher Education for creation of 2 posts of assistant professor in order to provincialize the petitioner and another person from the post of tutor assistant professors. But however, despite submission of the said proposal, no further steps have been taken in furtherance thereof, and therefore the petitioner is before this court. Next para, issue notice of motion to returnable by 4 weeks. As Bria, Leonard Senior Counsel,
1 and 2.
Higher Education accepts notice on behalf of respondent numbers 1 and 2. Miss R. Devi, Leonard Counsel. R. Devi, Miss R. Devi, Learned Counsel, appears on behalf of Mr. A. Chamwa, SC UGC, who represents respondent number 5. Out there, right?
Yes.
R. Devi appears and accepts notice on behalf of Mr. R. Chamwa. And who's the others?
3 and 4, your lordship. By register.
Petitioner to take petitioner to serve notice. Respondent numbers in 3 and 4 by speed post. Within 3 days. List again.
Your lordship may permit us to take dusty service on
3 and 4 also.
3 and 4.
Okay, 3 and 4. Na? Additionally, petitioner is also permitted to serve notice to them by way of Dasti within 10 days. And then file an affidavit as proof of service. List again also. And so.
Deeply of
My lord,
we were appointed as a cook, assistant cook and additional helper by the school management committee of.
Appointed as?
ME school, which was later
Appointed as-
amalgamated with Jagir Mahal HS school. Annexure one is the page number 19. Annexure one is the type copy of school management committee resolution, and annexure 3A, B, and C is the high card.
There are how many petitioners?
4.
You have been replaced.
Yes.
You have been
Yes,
replaced.
yes. We have filed in representation on 28/01/2000, annexure 6, page number 30.
What was the nature of your appointment?
It was appointed by the resolution of school management committee. My
You are appointed, you all were appointed as cook and assistant cook.
yes,
Who is cook, who is assistant cook, and who is additional helper? Amongst these four.
yes. That's it. Petitioner with is one day cook and assistant cook. An additional cook is petitioner.
One and two are cooks.
Petitioner cook.
1 and 2 are cooks.
Yes, yes.
And number 3,
Number 3 is
additional.
yes.
And number 4 is helper.
1 and 2 is a cook and assistant cook, and about 3 and 4 is the helper. That's it. My limited grievance prayer is that the direction may be given to the respondent number 6 to dispose of the representations by the petitioner on 28th.
Where is the
01.
appointment order of the petitioners?
Yes, check. Annexure 5, annexure, oh, sorry. Annexure 1 and the
1. 1 is the executive meeting
Yes.
minutes.
my name was reflected in annexure 2, Lordship, page number 21 in from the
Where?
6 from the top.
What is your name?
Salong Jan Bibi.
Chalojan Bibi,
Yes,
petition number 1.
yes.
And others?
Other than I don't know, they're not these pivotal. Sir, I-card was issued. The I-card was issued in next from 21.
Where?
22 page
Where?
number.
Where?
Page number 21 to page number 1 to page number
21 is the
25.
list. 21 is the list only.
Yes,
I-card starts from 22, I think.
yes.
Now page number 22, whose I-card is this?
আরেকবার বিবি petitioner
Where is the appointment of the private respondents?
no, I was not intimated to that. And
So how do we know that they were appointed in your place?
yes, when I approached to the headmaster, he handed over annexer 5, page number 28. It was a letter from the additional district commissioner to the
There was some inquiry report.
yes, but it was not provided to us, and not intimated.
What happened? You did not cook good meal, that's why they removed you.
But,
You're only cooking trouble, that's why they removed you.
But no documents was provided to us. We are unaware.
You're working, where are you working?
Uh,
I mean, where were you working?
Initially, it was a Jagir Mahal ME school.
Huh?
Jagir Mahal ME school, but later it was amalgamated with Jagir Mahal High School.
Amalgamated.
Yes.
Will issue notice. Headmaster
K. Kolita.
K. Kolita, learned counsel for the petitioners, who submits that the 4 petitioners were appointed either as cook, assistant cook, and helpers in Jogir Mahal ME school. Vilasi Parasite district.
Yes.
No?
Dhubri district.
It's in Dhubri. ME school, no? Vilasi Para, in the district of Dhubri. How long did you work?
From since 24/09/2008, 2008 to 03/11/2020.
21.
2024.
Stop, they were appointed as such on the recommendation of the school managing committee. By the resolution dated 24/9/2008. Stop, the petitioners continued to work as such till 3/11/2024, whereafter they have been replaced by the private respondent number 9 to 12. Stop, the learned counsel submits that the petitioners apparently were replaced by the private respondents on the basis of an inquiry report which was not given to them. Stop, in this regard, the learned counsel has drawn the attention of this court to the communication dated 29/11/2025 of the additional district commissioner (education) and district mission coordinator SSA Dhubri to the block elementary education officer Bilasi Para Block, Dhubri. Dated 29/11/2025. Bracket annexure 5. Stop, he summons that also. He submits that although a representation was submitted by the petitioners to the block elementary education officer, Bilasipara block, on 28/1/2026, but as the same has not been considered and disposed of, petitioners are before this court. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr. SUK, Learned Standing Council, Elementary Education, accepts notice on behalf of respondent numbers 1, 2, 5, 6, 5 and 6. Mr. S. Bora, Learned Standing Council, SSA, accepts notice on behalf of respondent number 3. Government advocate, who will appear? Ms. K. N. Fukan. Learned Government advocate accepts notice on behalf of respondent numbers 4, 5. As for the remaining respondents, petitioners shall serve notice by petitioners to take steps to serve notice to them by speed post within 3 days. Extra copies of the petition be furnished to the learned councils appearing for the respondents today by 2 days. List again on so and so.
But in this case, my lord, the petitioner has been deprived of my lord from holding the charge of the headmaster of the school, my lord. His name is page number 24, my lord, you will find serial number 5. He is having, my lord, B.Ed degree.
What
Serial
is
number
this
5.
name? Morin Gogoi.
Yes,
Munin. Monin or Murin?
yes. He is having a B.Ed degree and he has passed the B.Ed degree from IGNOU, my lord. And the remarkable, my lordship, is find it is written that he has no NOC while acquiring B.Ed degree. That is the ground for which, my lord, he has not been allowed.
Which school?
Page 24, my lord.
Which school?
Serial number 5.
Which school?
The school, my lord, Kenduguri High School, my lord. In below it is written name of the school. In the above also, in the top of the page, my lord, is written. At present, my lord, he is the senior most B.Ed holder.
Who has been given in charge?
It is given to IS, my lord. He is allowed to hold the academic charge, but the IS is given the
Financial power.
yes, page 878, my lord, and except 10. And this honorable court has repeatedly held, my lord, this it is not required, my lord. NOC is not required.
NOC is not required.
Yes.
Show me the judgment.
And the my lord, also this honorable court held that the B.Ed degree from IGNOU is also a valid degree. And except 3, the lordship will find 3 and 4, two judgments I've annexed.
Page,
Page 25, my lord.
relevant portion.
Page 27, Your Lordship. Para 4, page 27, para 4. This petitioner also had the B.Ed degree from IGNO, my lord. And
The main thing is, you have not taken NOC, that's why.
that's all.
Will issue notice. That is Mr. B. Prokasta, Learned Counsel for the petitioner. To submit that the petitioner is aggrieved for not having given the post of in charge headmaster of
Kenduguri High School, my lord,
Kenduguri High School.
in the district of Shivsagar.
Shivsagar. Despite being the senior-most teacher, having B.Ed degree and qualified to hold the post. Qualified to hold the said post. Gustav, he submits that although the petition has been allowed to be the headmaster in charge insofar as the academics is concerned. But the financial power has been given to the Inspector of Schools, SDC Sivsagar, by order dated 31/3/2026. To stop the Learned Counsel submits that the petitioner has been denied the financial powers on the ground that he did not obtain no objection certificate while undertaking the B.Ed for acquiring B.Ed degree. Brief above, you should notice a motion returnable by 4 weeks. Mr. U. Sharma, Learned Standing Counsel. Second education except conclusion. All the respondents. Extra copies will be furnished to you. within 2 days. List again on so and so.
But in the interim, I have made an interim prayer, my lord.
Should
For-
notice on the interim prayer as well.
Obliged.
It's returnable on the same date.
Obliged.
Mr. U. Sharma shall obtain necessary instructions.
80.
How many motions are there?
May I please?
5 more.
May I please?
Yes.
Lordship, in this case, petitioner are the 18-month DLED diploma holder. And accordingly, they had applied for the post of assistant teacher in the lower primary school, your lordship. As per the notification advertisement published by the elementary education dated 26/12/2023, your lordship. And after the application, your lordship, petitioner were not called for verification, your lordship. In this regard, your lordship, some other applicants among of them, your lordship, had approached before this honorable court by filing the writ petition, which was dismissed by the coordinate bench, your lordship. And thereafter, they have approached, challenged the coordinate bench order before the divisional bench, your lordship. We have annexed as annexer 8, your lordship. If your lordship will turn page 96, your lordship, the finding of the divisional bench, your lordship. Lordship.
Yes. We have listed this kind of matters on 13/5.
Same,
We'll list this on that day.
lordship.
Heard Mr.
S.I.
S.
Akan.
S.I.
Akan.
Akan, learned counsel for the petitioner. Petitioners.
Petitioners. 11 petitions.
Submits that by filing this writ petition, the petitioners have challenged the notification dated 17/6/2025. Where's the notification?
Your
Page?
lordship, at page 41, your lordship. Annexer 6.
I think it's 1F which you are challenging, correct? 1F, page
Yes,
41.
yes, lordship.
By which the respondent authorities concerned have insisted for UDICE records to prove the fact that the petitioners as applicants were in service as on 10/8/2017. The learned counsel submits that the same is not mandatory in view of the observation made by the division bench of this court. In writ appeal number. Where's,
345.
where's that page?
Page 96 image.
96.
They start from 89.
Writ appeal number
345, 2025.
345 of 2025, which was disposed of by order dated 24/3/2026.
26.
Bracket annexure 8. Sub next para, Mrs. Sutia, learned standing counsel, had elementary education on the other hand, submits that the writ appellate court, in fact, has upheld the decision of the learned single judge. And therefore, the said decision is not in favor of the petitioner. Stop. It is, however, noticed that similar writ petitions have been listed, are to be listed on 13/5/2026. And one such case being WPC number 842 of 2026. Let notice of motion be issued, returnable by 13/5/2026. Mr. Sutia, learned standing counsel, elementary education accepts notice on behalf of respondent numbers 1 and 2. R. Devi, learned CGC accepts notice on behalf of respondent number 3. Mr. Ayalam, learned counsel appears for the respondent number 4. NCTE. And IOS. They have a standing counsel. And IOS. Notice be issued to respond number 5 by speed post. Petitioner takes steps by within 3 days. List again on 13/5. Should we club it together or we'll just list it? Along with WPC number 842 of 2026.
So oblige.
Item 20.
Yes, Mr. Bray.
My lord, may I please your lordship?
Hmm.
My lord, basically we are aggrieved by of an order, my lord, which is at page 49, annexure 11, my lord. My lord, this is an order arising out of, my lord, a complaint. My lord, may I read, my lord?
Yes.
Whereas a public complaint petition dated 26/2/26 has been received from Afzal Hussain Laskar and 2 others of Bheloguri, post office so-and-so, district so-and-so, regarding the alleged fraudulent issuance of EU-DIS code in respect of United English School Bheloguri cluster under Jogijan Education Block. And now, my lord, this United English School is the petitioner before my lord today, my lord. And whereas the peruse the FIR filed by the Inspector of School HDC Hujai, by letter number dated against the United English School Bheloguri Hujai Assam. And whereas it is observed that the Inspector of Schools cum District Elementary Education Officer Hujai HDC in his report the wide letter number so and so dated 18/4/26 stated that he had received a report from the Director of Secondary Education Assam, wherein it was stated that no EU-DIS code was issued
in the name of United English School, Veloguri, from the said office. The related file was opened and processed in the name of Kopoha Adarso Jatiyo Vidyaloy so and so. Hence, the UDIS code used by the United English School Veloguri was fake and the said institution was running illegally. Now, my lord, thereafter, on examining the above matter and after careful consideration of the report submitted by the Inspector of Schools cum District Elementary Education Officer Hujai SDC, along with the report of the Director of Elementary Education Assam, the undersigned directs the Inspector of Schools cum District Elementary Education Officer Hujai to take necessary action for sealing and closure of the above mentioned school. The Inspector of Schools cum District Elementary Education Officer Hujai SDC will submit a compliance report to the undersigned within 3 working days. Further, the Inspector of Schools cum District Elementary Education of Hujai shall take necessary steps to accommodate the existing students of United English School, Veloguri in nearby educational institutes. So, my lord, this is the order impugned in this petition. My lord, if my lord goes through, the main reason, my lord, they have cited is that the UDIS code
Was fake.
my lord, the UDIS code which we are using is a fake one and it had been issued to some other schools, my lord, which has been named as Kapoha Adarso Jatiyo Vidyaloy Post Office so and so. My lord, just before moving this petition, my lord, there is a system in the my lord, Department of School Education maintained by the my lord, central government. My lord, I have checked the UDIS code in their official website. My lord, when we put the UDIS number in the official website, my lord, it reflects the name of the school. Right now, still this UDIS code is available in the name of the petitioner school, my lord, United English School, my lord. So therefore, prima facie, my lord, this, my lord, the impugn order, perhaps they have issued without the proper verification of the website as well as the all other records which are not available. My lord, we have also annexed the, my lord, relevant record of the UDIS, my lord, which we could find out from the, my lord, official website. I am just drawing my lordship's attention, my lord, to that page, my lord, is at page 24, my lord. My lord, this is the number, my lord, which is required to be given. The first 4 digit 1, 2, 3, 4, 5 is marked as this one. But my lord, if we put 1810005, 14007 in the, my lord, official website, the name of the present school can be, my lord, is available and we can find out the name of this United English School. Just, my lord, is still available at this moment also in the official website, my lord. So therefore, my lord, prima
24,
my lord,
page
page
24.
24, my lord, page 24.
This is a
And
printout.
this is a printout of the official website, my lord. Just before the day, just before the day of the filing, we could find out. And today morning, today also, my lord, in my mobile, my lord, it can be checked. And I have checked, my lord, I have found this code number belong to this school only, my lord. So therefore, my lord, my respectful submission, my lord, is that there is no fraudulent activity or any fake record we have used in the name of functioning of the school. Now, my lord, responding to this order, what the inspector of school, my lord, today morning came to the school premises and, my lord, it had been sealed. My lord, the law and everything had been used seals, and now there is a chaotic situation going on, my lord. The innocent students, more than 247 enrollments are there, my lord. And this is purely a school, my lord, which is imparting education and instructing education in English medium, my lord. Within the area radius of 5 kilometers, my lord, there is no my lord, parallel institution that these students can be accommodated therein, my lord. So therefore, my lord, it is a chaotic situation is going on. Now, my lord, the law which is governing the conditions for opening or functioning of this school is very much available, my lord, under the 2006 Act, my lord. The Assam Non-Government Educational Institution Regulation and Management Act 2006, my lord, can found in this manual, my lord.
Page.
My lord, I am straight away, my lord, can find the starts at page, my lord, 573, my lord. My lord, how this school is required to be established, all this private school has been, my lord, codified here in section 4 and section 5 is relevant, my lord. Section 4 is the prior permission for establishment of the non-government educational institution and registration. My lord, if we go by the impugn order, my lord, that there is no objection has been raised by the authority that we do not have the prior permission as well as the registration. That apart, my lord, section 5 says that the administrative recognition at page 578, that also we have, because the impugn order do not says that we do not have the administrative recognition also, my lord. So therefore, my lord, their main contention is that the DIS data or the DIS code which we are using is a fake one, my lord, which is absolutely incorrect, my lord. Relevant can be verified from the record itself, my lord. So therefore, my lord, if I can satisfy my lordships, my lord, that my lord can ask for an instruction, my lord, from my learned friend, my lord, as there is an emergent situation is there, my lord. The full swing school is going on, and now it has been locked and seal has also been used today morning, my lord.
From where do you find out that the VDAS code is available by this name?
My lord, if my lord can verify in the website, my lord,
Website of?
offside of the Department of School Education, my lord.
No, it's okay. I don't need to see that.
My lord.
We'll ask him to get instructions.
Yes, my lord. Yes, my
Mr.
lord.
Pisai. You are there? No, you are for the. For the government. SSA.
No, it
Who's
is,
the council, SSA?
no, my lord, the impugn arrangement has been made by the, my lord, the additional district commissioner Hujai, my lord. So the additional district commissioner can also, my lord, apprise my lordships, my lord, regarding how he has come to the conclusion that this diocese is not in our name, my lord.
My lord, if you are, there is the impugn order, my lord.
Hmm.
There is a clear report from the director.
Yes.
However, my lord, apart from that, on 31/2026, my lord, inspector of schools, my lord, issued a notice to the petitioner school to bring this document, my lord. They have got 31/1/2026, my lord. They have heard, my lord. After hearing them, my lord, this order has been passed, my lord. Even, my lord, my senior friend, he has indicated that the website, my lord, they should produce before the hearing, my lord.
My lord, that is the
And
issue,
that, my lord,
Yes,
that
yes,
is not in a part of this petition also, my lord.
no, my lord,
If it is their particular grievance, my lord, why they have not been before the concerned authority as in hearing the matter, my lord?
my lord,
Now we
even,
cannot affirmly say that that is in the website or not, my lord. If it is a website, my lord, there is a so-called notice issued, my lord. Thereafter, they have a hearing, my lord.
my lord,
There is no indication in the order itself, my lord, where they have had and they have produced that, my lord. Now they are come before this court is another plea, my lord. They're saying that no, it is the director website. If it is true, my lord, they have to place before the authority, my lord.
my lord, my friend is absolutely correct, my lord, and we have approached the authority and we have produced the document. There is no mention in the, my lord, regarding our appearance, because, my lord, may kindly peruse page 48, my lord. Page 48, my lord. Annexure 10, this is a notice issued to us, my lord. Now, responding to this notice, my lord, when we approached before the authority, my lord, when we apprised them, they even did not, my lord, bother to record our statement or peruse our records, my lord. Straight away, this order had been issued, my lord. There is no mention regarding our appearance and our hearing, my lord.
That, my lord, they are not coming against that allegation.
No,
They
that
are-
allegation
it
is not
impugn order,
required, my lord. The impugn order
If the
itself
statement
reflects,
of
my lord.
my senior is correct, my lord,
My lord.
then, my lord, they come before this court by taking another allegation, my lord.
No.
That
It
this
is not the
petition.
question of allegation. It is a question of record, my lord. Because their speaking order does not say that we have been heard.
No, notice has issued and.
No, notice was issued and we have
hearing
appeared.
also there, my lord.
We have-
That impugn order, my lord, page number 49C.
We have annexed the
It's, my
notice
lord,
also,
clear,
my lord.
Report also come from the director, my lord.
You take instructions.
And
My
We'll have
FI
it-
also filed,
We'll have it some
My
other
lord.
day.
my.
Heard Mr. A.R. Bhuyan, learned senior counsel, assisted by Mr.
H.A. Talukdar, my lord.
Mr. Talukdar for the petitioner who submits that the petitioner is the United English School
Even he report to them. Report to them.
situated at Bheloguri
I-
in the district of Hojai. and is aggrieved with the order dated 28/4/2026, by which it is held that the UDICE code used by the school is fake, and therefore the school is running illegally. To stop. The said order has been issued by the Additional District Commissioner and Education, Hojai, directing the Inspector of Schools, come District Elementary Education Officer, Hojai, to take necessary action for sealing and closure of the school within 3 working days. To stop in terms of the said direction, the Learned Senior Council submits that the school has been sealed and closed this morning.
Today morning, my lord.
To stop. The Learned Senior Council, however, submits that the impugn order dated 28/4/2026, wherein it has been stated that the school has been running under a fake UDICE code. Is completely wrong. In view of the fact that in the website by entering the UDICE code of the school, the name of the petitioner school is clearly reflected. To stop, although the petitioners have raised this at the time of hearing on 31/3/2026, but when was the hearing?
My lord, it was scheduled on MD, my lord. Notice.
31/3.
31/1/2026.
What was I say? But the respondents failed to record the claim made by the petitioner school. Therefore, being aggrieved, the petitioners are before this court. Will issue notice or we'll get instructions?
The instruction is required because, my lord, some interim order, my lordship can satisfy on the next date, my lord.
Learned Senior Counsel submits that since closure of the school has created a chaotic situation, an interim order may be passed by this court, allowing the school to run. Since the interest of as many as, how many students?
244 students.
244 students is involved. Considering the next para, considering the above projection, Mr. P. Sankhya, Learned government advocate shall obtain instructions in the matter by the next date. List this matter again on
Next Monday.
when?
Is this lordship like a Monday?
What,
1 week, Monday.
my lord,
So what is that next Monday? 10th, 11th,
my lord.
list again on 11th, 11 May 2026. An extra copy of the writ petition
Yes,
is
yes,
furnished to
today
Mr.
itself
P.
is-
Sankhe within the course of the day to enable him obtain instructions.
My lord. Obliged, deeply obliged.
How many matter now? This is what, which matter is that? 20, no? There are 4 more motions. Let us finish it. Let me try.
May I please, Lord?
Yes.
Lord, here, my lord, the petitioner, my lord, he was elected, my lord, as president of school management committee, my lord.
Hmm.
And it was approved, my lord, on 29/1/2024. And term of the committee, my lord, is 3 years. And now the impugn order has been issued, my lord,
Page.
page 29.
Yes. What does it say?
My lord, by this order, my lord, the BO has been allowed to act as president of the school.
School management committee.
Yes, my lord. Neither the petitioner has been removed, nor he has no confidence motion was moved, no inquiry was sought. And this order, my lord, is absolutely, my lord, in violation of Rule 13, my lord.
Rule 13. Page number.
Page 255, my lord. Article 1, my lord, composition and function. Then 3, my lord, is selection procedure. 5, my lord, sub-rule 5, page 259. So, now removal, my lord, is, my lord, only allowed, my lord, in case of
See.
no confidence motion,
This impugn order is only regarding the president.
lost, only president.
Others are there.
Others are there.
Okay. Will issue notice?
Now, my lord, this condition has not been fulfilled in any way, my lord. Neither he has been removed, nor, my lord, any motion was taken place. And impugn order, my lord, does not say anything, my lord, except one inquiry report.
Mr. Sankhe, you will
Lord.
obtain instructions also in this case.
My lord. Then
So,
by-
petitioner indicated some report, but that report is not a part of this petition.
report has not been furnished,
That is the
so it
problem.
could not
So we have this also on Monday,
lodge.
next Monday, 1 week,
Matter Wednesday.
Wednesday. Okay. Heard Mr.
Our element.
R. Ali, learned counsel for the petitioner, who submits that the petitioner is agreed with the order dated 12/3/2026, bracket annexure 5, by which the post of President, School Managing Committee of Barpukri LP School, Ojai, has been taken away from the petitioner and the charge given to the Block Elementary Education Officer, Lanka. Top, the learned counsel submits that the petitioner was duly elected as the president of the school managing committee in terms of the relevant provisions of the Assam right of child to free and compulsory education rules from 2011. Stop, however, without adhering to any provision and in violation of sub rule 5 within bracket 5 of rule 13 of the rules of 2011, the petitioner has been removed through the impugn order. Stop, he summons that the same should be set aside. Next para, considering the above projection, Mr. P. Saikal on it. Government pitch shall obtain instructions in the matter by the next date. Extra copy of the writ petition.
Because for the moment, existing litigation, that
Mr. Saike is not required then.
My lord, she
Only-
can obtain instruction, my lord, because my lord. that's-
Okay, right hand. S. Sutkal and standing council, elementary education, instead.
Correct.
Shall obtain instructions by the next date. Is the matter on 13/5/2026. Extra copy of the petition be furnished to Ms. S. Sutkal within the course of the day. Give her one extra copy.
50 of the subsidies.
Okay.
May it please your lordship, my lord, kindly see the last order, my lord. We're
Yes.
Supposed to get instructions, my lord.
My lord,
Before that, you tell me, because it was not this court who sought for instructions, who directed
My lord,
the,
this matter relates to, my lord,
Hmm.
non-sanction of maternity leave, my lord.
What are the petitioners?
Petitioners.
They are teachers,
Yes, my lord, teachers,
teaching us
And-
what?
and my lord, the
Please
matter,
listen. They are teachers of which school and what,
yes, my lord. One by one, my lord, firstly, my lord, the 50, only one petitioner.
Hmm.
She is the teacher of
Okay, yes, what is the instruction?
my lord, we have received a detailed pairwise comments, my lord.
Ah,
Would like
So you want to file that? Let him file the instruction. Mr.
H. Burwa, my lord.
H. Barua, learned, standing counsel,
On behalf of Mr. B. Gogoi, my lord.
learned counsel appearing on behalf of Mr. B. Gogoi. SSA,
SSA, my lord.
standing counsel's SSA submits that a detailed paravise comments has been received and prays for some time to file the same by way of an affidavit. Considering the same. How much time should you require? 1 week?
2 weeks, my lord.
2 weeks' time is granted. As paid for. To file the counter affidavit. List the matter again also and so. In the motion column.
Obliged, my lord.
my lord, similar, my lord.
Similar matters, my lord.
These three matters are same, I think.
Yes,
Same,
my lord. Different schools.
You file it, okay, so that
My
we
lord.
can
We'll
dispose
bring
it
it on
of.
record.
Motion is over. How many orders matters? Okay. See, the remaining matters, you'll get a date. I want to rise. You can inform the court master. You'll get a date. Any interim orders.
Lordship,
and all
item
that.
number 38, Lordship, there's some urgency in the matter. The person has not got the pension for last so many years. And there's a direction of this honorable court. If the pension is not released by today, and there is a direction of personal appearance of all the contemnants, Lordship. Your Lordship, kindly take up this particular matter because for last 5 years, he has not received the pension in spite of the fact that there is repeated order of this honorable court, Lordship. And there is a direction of personal appearance of the contemnants, but not following the direction of this honorable court. Lordship can fix the matter day after tomorrow at 10:30 because they have not released the pension till date.
Appearance is there.
Personally, Lordship, kindly see the last order, item number 38.
This is item number.
38, Lordship. In spite of several directions of this honorable court, they have not complied with the order.
They have complied with the order. Direction is at page 16 of the sheet. Page 15 of it.
What do you mean by pro rata pension?
That's it.
What do you mean by pro rata pension?
The proposal that he served in the Kasar police.
So that was supposed to be decided.
Yes.
That has already been
Page
decided by the
15.
last order, Lordship.
Page
Page.
15 onwards, the direction of the contempt petition. That's it. Page 15.
Page 15.
Page 15. Paragraph 11. That's it.
Hmm.
Paragraph 11 is very relevant. So now after calculating, we have forwarded to the AZ. Now it's the AZ to decide, and if there is any lordship lapse, then AZ will lordship.
Service has been approved. Now, what is the question of pro rata pension? Then is the absolute misstatement of fact, Lordship. Service has been approved. The entire past service has been approved by this honorable court. Now they are saying it's a pro rata pension. It's not a case of pro rata pension, Lordship. It's not a question of proportionate pension. The entire service period in the Kachar College has been approved by the concerned director.
Okay. Moreover, lordship, in the contempt petition, the accountant general has not been made a party.
Direction.
Yes. Check. Paragraph 16, page 16, lordship, the direction is there that page 16, paragraph. The respondent of the as well as the accountant general, Assam shall do the needful. Now we have done our part, we have forwarded to the accountant general. Whereas the accountant general has not been made a party in the contempt petition now.
Please write down. By filing this contempt petition, the petitioner has alleged non-compliance of the court's order dated 16/2/2023, passed in WPC number 4301 of 2022. Bracket annexure A1. Mr. A. R. Taibildar, learned counsel appearing for the respondent.
Number two, Lordship.
Number 2, submits that.
Respondent number two. I am appearing for respondent number. Respondent number four.
Respondent number 4 submits that. In terms of the last court's order, he has received instructions from the Joint Director of Higher Education, Sam. And he produces a copy of the said communication.
Lordship, joint director as well as the. Lordship,
Data.
from the Lordship.
Dated 22/4/2026. Stop. Additionally, the Joint Council has also produced letter dated 27/4/2026. Written by the Deputy Secretary to the Governor of Assam, Education Department, to the Principal Accountant General Assam. Considering the same, let the matter be listed on Wednesday. Day after tomorrow.
Lordship, item number 49, Lordship, the interim order was supposed to be considered today, Lordship. Lordship, may kindly take it up on Friday, Lordship. Item number 49.
We'll see. Master, we will see what.
Lordship, can it be taken over 7th, Lordship? 6th, I'm having some difficulties. Huh? Then 8th, Lordship.
It is Friday, why?
Then no, 6th, 7th.
Then you go for Monday then.
Monday.
For Monday, list on 11th.
My lord, I beg to mention item number 26.
I've already indicated, see, I'm not feeling well, that's why. Since first half, I'm not feeling well, but because of the motion matter, I'm sitting. Please understand.
Sorry.